because it's part of matter. So item number one. Oh, sorry, item one, vote number 12. Before appropriate benches, it is submitted by the councils that the matter was substantially heard before the court.
My Peter Lordship, but with the consent of the other side, I like to mention item number 9. In this case, Lordship, an enquiry has been initiated. An enquiry was held on 27 July 2023. Lordship, your enquiry report yet to be received. Lordship, 3 weeks may be done. Lordship.
Item 9 of vote number 13.
What was item, Lordship?
Who's for the petitioner?
A Dasgupta, Lordship, I have telephonic instruction, we have consent.
We'll give you 2 weeks at the request of MS
G. Bora, Lordship.
G. Bora and the council appearing for the
Agriculture Department.
Agriculture Department. The matter stands adjourned, enabling her to obtain the inquiry reports stated to have been submitted by the inquiry officer / committee in the government. It is submitted that consent of the council for the petitioners have also been obtained. Just after 2 weeks.
Thank you. Lordship, I have given a copy of the enquiry order. Lordship.
What is it?
Madam, item number 1, we have filed additional affidavit lordship in this case. That is not on record lordship. Yesterday we have filed. Madam, here also my sign it, but here also 30 submitted madam in this case.
Bring it on record at 2 p.m. or as soon as possible. Call for the additional affidavit. You give a slip. You give a slip to the court martial. You get. Yes.
No, very urgent with our reducing the matter, Pisari matter. Can you do the Friday?
Fresh matter.
Not fresh. Today, 22 matter. Now, one the settlement.
Which court? Which court?
For now,
12 matter, urgent matter, we can take it up today if you want. Not possible. So you'll have to make a mention. Accordingly.
Friday?
No, is it listed today?
No.
Not listed today. Alright, you submit a mention memo. You submit a mention memo. Yes.
Diblo. May I tell you? Plan table, we matter for motion. The matter relates to lordship settlement of market lordship, and the petitioner is the highest bidder.
Court number 12 matter. You should make a mention before that court. It's a fresh matter.
Yes, sir, the motion matter.
Only. But when did you file it?
Lordship today file lordship may.
Today is your file. Why are you mentioning it? It will come on its own by Friday.
Lordship, they are going to settle lordship with the respondent.
When do you want
27.
huh?
They have lordship.
When do you want the matter?
Lordship tomorrow.
Tomorrow is not possible. You can have it on day after.
Or like. Yeah.
I get better. 3129 WBC because it was last posted on day. Which court matter? Bench court matter. So you come up. When do you want it? Monday. Monday. All right, Monday.
Daily list for hearing item 2.
Lordship, on the last occasion, respondent number is present. This is important. Who is the respondent 3 here? He was junior to me. He was considered for promotion. The respondent number 3 doesn't appear. That is his problem. His services are complete. Yes. What is the issue here? Is anything alive in this matter, 2011? I think it has become infructuous. What is the stage, Mr. Lord? What is, somebody was promoted in some post? Respondent 3. Now, what is the stage of the respondent 3? Yes, Mr. Solomon.
From our affidavit, Lordship, if the Lordship comes to our affidavit.
Hmm. It is filed by respondent 3. Affidavit on behalf of respondent 2.
On behalf of respondent number Lordship 2.
Bhupati Bhushan Roy.
Yes, Lord.
Yes, yes.
In the repetition, Lordship, they have challenged the promotion of the private respondent, that is annexure 4. Annexure 4 at page. Page 36.
Yes.
May I read, Lordship?
Hmm.
Page 36, annexure 4.
Ah.
There was the application of state so and so PBX operator civil defense junior Jorhat forwarded by additional deputy commissioner and in charge of the civil defense Jorhat Vice letter number so and so. The applicant was appointed as civil operator vice director of so and so Assam dated so and he joined in service on 3/11/91 and since then he is continuing his service in the same status at the same station. From the departmental record, it is found that the applicant has not been so far encadered in any grade of service in the civil defense organization of Assam. He is confirmed in the service of PBX operator by Director of Civil Defense and Home Guards, order number so and so. The scale of pay of the so and so, Lordship, then Lordship may come to the next paragraph. I have gone through.
Yes, yes.
I have gone through the provisions contained in the Civil Defense Non-Gazetted Service Rules 1991 and amended rules of 1998. It is provided in the amended Service Rules 1998 as amended of Rule 5 as amended Rule 3 that in the substituted that in the principal rules in Rule 5.1 in Sub-Rule 1 of Clause A and B. The following shall be substituted, namely recruitment to the cadre of civil defense demonstrator, civil defense wireless operator shall be made by direct recruitment. For sub-rule 2, the following shall be substituted, namely notwithstanding anything contained herein before. Under sub-rule B, persons appointed to equivalent post in the civil defense department before commencement of these rules shall be treated to have been encadered in civil defense demonstrator and civil defense wireless operator. The higher grade of both PBX operator and the wireless operator demonstrator is assistant deputy controller junior and there is no any further cadre. On the basis of the amended rules, this order is passed. So far as relevant rules and general principles of seniority is concerned, the relative seniority of all direct recruits is determined by order of merit in which they are selected for such appointment on the recommendations of the selecting authority and the persons appointed as a result of an earlier selection being senior to those appointed as a result of subsequent selection. The departmental records has revealed from the existing updated gradation list of demonstrator wireless operator of civil defense is that all the incumbents of the same list are appointees of different dates starting from 21/3/1994, whereas the applicant being the appointee of 1/11/1991 and joined in service on 3/11/1991. Under the circumstances stated above, Sri Basanta Dutta, PBS of the Civil Defense of the Goa deserves to be entered in the General Service. So this order was passed on the basis of the amended rules, and they are challenging this order.
Without the rules being challenged.
Yes, that is our main contention.
Where is the rules? Where are the rules?
I have not the next item.
Lordship, can this matter be taken up more on Lordship? Lordship, and somehow replace the liquidation.
It is difficult then, but.
At the request of learned counsel, we petition to submit that his case has been dismissed. Let us send him to Thursday,
Lordship.
enabling him to reconstruct the case. Matter be listed at the top of the list.
Promotion of 2011, whether it still survives or
That
not.
is what we wanted to know.
Lordship. Much of that.
He may, you find out if the person in the meantime has also been promoted further, must have been,
We will.
or the post is vacant or anything like that. And get a copy of the rules.
Lordship.
Yes.
Item number 3,
My lord, in this case, the matter was listed, the instance should be appointed by.
Hmm.
And in this case, my lord, what we challenge the, my lord, the removal of the petitioner from service
Hmm.
as a major penalty. Only thing is that, my lord, my counsel there, lordship, matter may be taken up on stand, my lord, hearing day.
Why?
Because, my lord, I need to go through some judgment, my lord. Place it before the court. I'm not saying much time, my lord, from 10, but
First, tell us what is the issue about?
yes, sir. Lordship, kindly say P1 annexure, page 18, page 70. Where is
7017.
170?
Yes.
Whereas disciplinary proceeding against Toronto from the N. Kapoor Industrial Security Force, they said Duliaja is contemplated. Now therefore, the understanding exercise of power conferred under Bible Toronto, they the 2001 have been paid the above state enrolled member of the court under suspension with immediate effect. It is further ordered that within the period of this order shall remain in force. The headquarters of the above state enrolled member of the state board. So shall be industrial sector headquarters, ASF in Coil Buliaja and bank constable number 22 shall not leave the headquarters without obtaining the prior permission of the undersigned, my lord. Then, my lord, next is the, my lord, charges were communicated. Charges, my lord, page 20. Third one, post number 24 JN Kapoor, who is posted in the industrial sector in CISF in Duliajan that from 20 to 29, 2008 at around 00450 hours without any special research. He created an atmosphere of disturbance and every board members so with the default where his face enraged for the service title a participant issued for duty and pointed it at his death. This act of force and so great misconduct, irresponsible behavior and indiscipline and also expecting criminal nature. Next starts to so Kapoor is posted in the industrial sector in KSF in Buliajan. That on 29/20/2008 at around 24 hours, he left his post at the bank from bedside watchtower without the permission of his superior officers and without handing over the service title so issued to him for duty and with the purpose of influencing the department came to his official residence and locked himself with the prison. This behavior of a member of an armed force shows great indiscipline, misconduct, and irresponsibility. Then first three, Ranso Kapoor is posted in the industrial sector in JSF venue Buliajan that on 29/2008 at around 8 hours. When HC DK Stewart, Unique Creation and HC Tech, they PK they wrote CHM ordered him to come out of his quarter and surrender the weapon ammunition. He threatened to fire at them. This act of force number so and so has shown great indiscipline, irresponsible behavior and great misconduct and also his criminal nature. Then last charge number 5, post number so and so, Kapoor, who is posted in the industrial sector in CSF unit Viajan, that during his 7 years of service, he has committed acts of indiscipline and misconduct and got 6 punishment. And along with having a bad service record, he has acquired the incorrigible habit of repeating indiscipline, misconduct, irresponsibility, and ignoring lawful orders. Out of these 6 punishment, there were 5 for quarreling, dereliction of duty, and irresponsible behavior. These are the 5 charges. Then, my lord, inquiry was conducted by the inquiry officer at page 26, and he has submitted the report at page 26. Inquiry. It's a long report, my lord.
It's a fairly exhaustive report.
Lordship?
It's a fairly exhaustive report.
Yes, ma'am.
So a lot of evidence has been properly
Yes,
discussed.
my lord. My evidence, page 28 in my defense statement.
Hmm,
Defense statement. Page 28.
yes.
The delinquent force number so and so, DN Kapoor, under suspension industrial sector CISF, in his statement of defense, stated that he cannot say about the charges level against him due to his mental disorder, and presently he has recovered. In support of defense, the delinquent has submitted the medical paper, right, exhibit number so and so.
Where are your written statements?
My written statement, my lord, then after inquiry, I have submitted my written statement.
Before that,
Before them, I'm not submitted, my lord. After inquiry, I was given opportunity to submit, my lord.
that is for punishment.
Yes, looking for punishment.
Where is that?
Page 71,
71.
represented. With management,
Hmm,
with due respect and humble submission, I beg to refer to your memorandum of so. In this connection, most respectfully, I beg to state that following for purpose of your kind consideration and purpose of order state that I am innocent in the allegation level against me are not true. That at the relevant point of time, I was suffering from mental disease, and as such, I do not really know.
Do you have any medical
Yes,
documents?
my lord. I was admitted on the date of the occurrence. He was admitted to the Duryodhan Hospital, Royal Hospital.
Where is that?
There, that I have stated, and thereafter, he was, that is, my lord, and it's
175 pounds.
175.
page, P10, 175. This is the discharge certificate in which he was, before that, my lord, incident was taken place on 28/2028, my lord. On the same date, he was admitted to this Duryodhan Royal Hospital, and on the next day, he was discharged, referring him to AMCH Dibigor. Accordingly, he got admission in AMCH Dibigor on 22/9/2008, and he was discharged on 4/10/2008. In the top of the Department of Psychiatry. He was admitted.
Hmm. What was your disease?
And what that is not reflected,
Then
that is reflected, but
where is it reflected?
my disease. in this
What were you
discharge
suffering
certificate,
from?
F23 according to ICD-10. In the discharge certificate, my lord.
Page number 178.
Page 175.
175.
175.
Hmm.
Column 4, my lord. Top psychiatry department, you was stated, then name of the patient, then date of admission, then disease, F23 according to ICD-10.
What is F23?
And
176. Dr.
One-
Sinha.
176.
Yes.
Then 177 is the document to show that he was admitted on 29,008 at 12:40 and discharged on 21/9/2008 at 2:20 PM. Referring him to the Bigoro MCC. Patient referred to Assam Medical College and Hospital Psychiatry Department for further management. Page 177. Acute malady. Then it was diagnosis, acute psychosis, patient a case of recovery state of acute hepatitis left also health negative.
What is there in the second paragraph under the brief of case history?
If there is no significant past injury, mental illness, no insanity, but because after 1 month treatment, he recovered from his malady.
No, this is case history. See the heading, case history.
State malady present insanity of or mental illness.
This is the case history.
Yes, sir.
What is that in the beginning? Case history. Patient had a
Patient had a stress when the use and so he used to sit back in home.
maybe you suffered from some depression, etc. But was it so acute that you did not have control over the situation?
And on that day, what happened to the other side, one of the his friend has made some statement about his wife.
Well, you know the law that in departmental proceedings, we are not a court of appeal.
Yes.
So we only have to see if there is any
Well, we
prejudice.
have on limited purpose on whether this major penalty is not sufficient for the purpose of. And so far as
You
the-
tell us why not. You tell us what is your argument that why this is not sufficient.
That is what my lord, on test may be fixed.
All right. Tenth, he wants some more ammunition. Tenth, as requested by Mr. Chaudhary, is the matter again on tenth. For further hearing, yes. For further hearing. MS B. Sharma, please for the respondents.
Item number 4.
Yes,
Is the removal measure after holding capital
from that oil company.
on the company, man, 8 years.
Yes, Mr. Sharma.
People similarly here, okay, this is my senior start, okay. And
There's nothing to start, we have already heard him. We have heard him. It's a case of removal. Removal.
My case is the matter, there were 3 charges against me
Hmm.
and going by the attending fact. All the charges were not mentioned on the case in the report. First charge is matter from 2002 to 2009, I remained unoperatively operative. Case recorded the documents attached to the repetition show that from 2002 to 2009, I was struggling to join.
Let us go through the charges again.
My
Page 38.
page 38.
Yes.
Charge number 1, madam. The committee Kumar Dhova, while he was working as executive operations officer at Transport, had submitted his resignation from the office of the corporation by taking immediately. His acceptance of resignation to Transport but subject to clearance of all outstanding dues from the corporate, the original Bola for the price, the letter is expensive. That he continue to be an employee of the corporation, and that he should attend to such assignment as the executive given by his immediate peers till the time he is issued letter of credit. However, he reported that the of this Kumar Bola did not report to duty and remained absent from the practice without any students or leave permission. Prior continuously from 23 days 2002 onward. Onward means if you come to, I think, come to know, it is 2009. In the order it is mentioned. The Yogesh Kumar Bola has been negligent and sold lack of interest by weekly remaining subjected without price. The Yogesh Kumar Bola unpaid absence and mentioned above that is not discussing the business person. So these are charges specifically.
For how many days you were absent?
According to them, from 2019, 10, 2002 to Mala, till our placed in the suspension Mala. And there's a fact Mala in 2009 Mala. Pursuant to 2 requisition, 1 recapping, 1 SMC Mala. Finally, they allowed me to join in 2009 because this court passed a judgment going by the fact, attaining the fact that the action of the HCCL in not allowing me to join was illegal. I should be considered into being.
No, let us come sequentially. First, this, you had submitted a resignation.
I prepared last time your Lordship asked me to prepare a date chart. I prepared it, it will go this to the very clear manner. On 1910-91, I was appointed as steady officer in HPCL Guwahati. Then 21, I was appointed as an officer. And 4/9/2002, I was transferred to Kolkata as executive operations officer, which is in the level of deputy manager. 19th of October 2002, petitioner tendered resignation. My 22nd 10/2002, there is after 3 days. I was duly released by HPCL. But may kindly have a glimpse to page 56. This is the crux of the matter. They say that I just dropped the resignation letter and left the office matter. It is not correct. Page 56 matter. 56 matter.
Yes. Yes.
This is photo, they say matter handing over, taking over. Left side Malak, AK Bolwa, this is Michael Malak. Duration of current position 1 year, transfer to so design, letter of reference so handing over 22nd 11/2022. Right side, the person Palash Acharya, who has taken charge from me. This is the format. After this HO signed Malak, I was released from the office. Now, Rashmi kindly come to the date chart again. So I was released, madam. Then 18/6/2003, madam. I was communicated that acceptance of resignation was made subject to clearance of housing loan taken by the petitioner. I took a housing loan, some amount was due. She said that if you pay it will be accepted. 27/4/2004, petitioner asked for some time to pay the loan since he started a new business. Madam, this is the second chart. They say that you being in service, how can you start a new business? This is the second chapter. 30th of August 2004, madam, petitioner withdrew his resignation and applied for VRS. In the meantime, the VRS came, they did not accept my resignation, so I withdrew it and applied for voluntary resignation. Madam.
No, they did not accept because you did not clear the housing loan.
Yes, sir. Housing loan, that's the reason they said that your resignation is not accepted. Therefore, my resignation not been accepted, madam. I continue to be an employee of HPCL. So I applied for VRS. VRS was rejected on 29/9/2004 to the petitioner. However, the petitioner was not allowed to join. Then I finally.
Were you placed under suspension then?
No. I will also tell you, at what stage after SLP they have taken the back in service in the form of suspension.
Then,
Then I filed a repetition matter. WBC 7022. Since its DRS was rejected matter on that term matter. HPCL also filed a money suit matter, MS also at Guwahati for recovery of housing loan.
What happened to the writ petition?
Repetition matter, repetition locality 10/1/2007. Repetition withdrawn on verbal assurance that the petitioner would be allowed to join. 10/1/2007 petitioner submitted joining report, however, the petitioner was not allowed to join. Now, the second date petition was filed. WBC 22 was filed by the petitioner again with a prayer to allow him to join.
Yes.
2008, repetition allowed by the honorable court holding that the petitioner to be considered in service and order to be reinstated in service with liberty to take disciplinary action on him due to his absence. Now, this judgment matter contains everything matter is the only lengthy judgment plus the permit matter I have to read it. What about their stand before the learned signature and what are the finding of the learned signature matter?
Okay,
That is a
we will come back to that.
It must, matter. Then they filed a repetition, a writ appeal matter. 218/2008 matter. On 25/3/2009 matter, this court passed an order that there was no stay order to the learned signature order. In spite of that matter, I was not taken back in service. The division bench said that the court is drawing contempt of court against the HPCL matter. This judgment is clearly mentioned matter. Then they preferred an FLP, FCP number 20, which was repeated. Then matter, 13/4/2009 matter, the petitioner was placed under suspension due to unauthorized absence in compliance of the order of the court. That is page 34. Then a charge memo was issued on 15/4/2009 matter, immediately after 2 days matter. This is the charge sheet that they will. Then 19/5/2005 affidavit filed in it, this is not necessary matter. This honorable court passed order to hold it. This is also not necessary matter. I filed written statement on 8/5/2009. 20th of May 2009, inquiry officer, treasury officer appointed. 14/10/2009, suspension was revoked and the petitioner joined in service. Then 8/3/2010, corporation acknowledged receipt of rupees 1,64,000 for loan repayment and passed order for repayment. That the petitioner will get 1/3 of salary and 2/3 to be adjusted with the balance loan due. So this is also regarding the third charge matter. They say that I have misappropriated amount. My thinking that my due amount was 5 lakh and they have recovered from me about 17 lakh. The petitioner issued letter agreeing with deduction up to 50%. Result the lawsuit may speak for a moment. 28/3/2010 inquiry report was submitted. I will next that matter. Petitioner submitted this report. Then this interim order was passed on 3/10/2011. The interim order was passed.
In 1410, suspension was revoked
And
and you joined in service, you were reinstated
because
in the same post.
it's the same. Then they passed this order 8/3/2010 for recovery of the loan amount. I was getting around 1,20,000 matter. They have deducted 80,000 per month. And see, by the time I was removed my lot, in total, they have recovered from me about 17 lakhs and all, again, 5 lakhs and all matter. How, what calculation don't not know. That's why my lord, the money should they find here, my lord, in Guwahati for recovery. That was disputed. Even then, they are not pursued because they have got their money. So this is the third charge, my lord. They say that I misappropriated money regarding a house loan.
Against the charges which were wrong,
Ma'am.
did you file any WS?
Yes, ma'am. Yes.
You filed.
That I played, my lord. That page 52.
No, in this list of dates we have.
Yes, 8/5/2009, my lord. I have given that in nature also. Page 2, my lord. So my lordship, if the lordship goes to the judgment now, my lord, in the judgment passed by the state judgment, my lord, there HPC has taken a clear stand on affidavit saying that employer-employee relation between me and the HPCL was broken, and they were not prepared to take me back in service. Having taking that stand, my lord, how they can say that from 2002 to 2009, I remain unauthorized absent. So first charge falls to that way, my lord. It is only a vindictive action, my lord. Since the-
Let us see that order
Well,
by which you are taken into service, back into service.
well, suspension remove that one. Or taking in the suspension.
First, you are not allowed to join.
Then.
Then you came to the Supreme Court, it was dismissed.
Then,
Then you are allowed to join.
no, not, yes, but they have to join in the form of suspension.
Where is that order?
That is my page 30,
Page
34.
34. Yes.
While we are working at executive operation officers, you have submitted the deviation from the private and you are equal therefore within look, the penultimate paragraph from below, my lord, it will remain under suspension till further order, during which period of suspension not be allowed to dismiss the member. And they say that DP is contemplated. So from this date, your lordship will deem it that I was taking that into.
When you paid your salaries. Subsistence allowance
After that everything, but they deducted my lord 2/3 of my salary
for
to
household.
recover the housing.
So you received your pay from 13th April? Or
From-
prior?
No, madam, on this date, that's why I was from 2000 to 2002 to 2009, no payment, madam.
Did you claim for arrears?
But here I am claiming everything, madam, they did not give me.
Hmm. Then,
And there is a finding, my lord, by the signatures, I will come to that, my lord. Signatures have said that from 2000 to 2009, regarding the payment of salary, they have to take a decision. They have taken a decision in the Tribune order, my lord, simply saying that you cannot enter into it. At least, my lord, if this honorable court holds that I should not be, I am deemed to be in service, my lord, at least I should draw the substitute announcement.
where is that 1410 order?
1410,
1410,
suspension revoked,
revoked,
that is page 50, my lord.
60.
No, that is only a state matter. That order I have not explained. And reply also they also stated that this order is not an expense.
Is not here.
It's not here, man. But they have admitted it in their reply, man. There is no dispute with that.
Yes. So insofar as the DP is concerned, the first thing, according to you, the first article of charge does not lie because you are not allowed to join.
I was not allowed to.
Then the second,
Second is regarding my lord,
carrying on business.
business matter. And Lakshmi kindly see, my lord, after I under my resignation, my lord, at no point of time they have not said that your resignation is accepted or that,
And the third is housing loan.
and third is housing loan.
Now, housing loan has been recovered.
Recovered, madam. I can give the calculation, 70 lakh there, more than 70 lakh they have recovered. 80,000 per month for a long time they deducted,
And where is the order of the disciplinary authority?
madam, that will be 125, madam.
Yes.
In the inquiry report and the disciplinary authorities order, my lord, will find these facts that I filed two petitions, read that in their file, SLP their file, and finally, on the state of contempt, they have allowed me to join, they did not allow me to join. Nothing has been mentioned, but they have recorded the things which are not. The person who signed the photo matter, handing over, taking over, his position is clearly take that this was signed by me and was approved by the higher officer. In the inquiry, he has deposed. That witness was brought by me, obviously, Mela HPCL did not bring it.
Yes.
My lord, kindly two paragraph of the judgment was in penalty matter. I wanted to read matter. That is the draft of my case matter, page two paragraph I read matter. Page 22 matter. Second expression when I filed matter and the court held that I should be taken to be considered that page 24 where Roshni kindly come to matter.
Page 22.
22 start matter. 24 I want to paragraph I read matter.
Yes.
24 matter.
Yes.
The respondent corporation has stated, has resisted the repetition by filing affidavit, wherein the respondent corporation has contended in India that the relationship of employer and employee, which once existed between the petitioner and the respondent corporation, had been broken by the petitioner by abandoning his service after submitting his resignation. And since the petitioner was no longer on active role of the respondent corporation, the petitioner is not entitled to rejoin his post. Having taking this time, my lord, how they can say that I remain unauthorized this time. And last paragraph, fifth matter, the finding matter.
Yes.
What emerges from the discussion is that the petitioner has remained in service of the respondent corporation till date. The question as to whether the respondent corporation is or is not liable to pay the petitioner the wages for the period during which the petitioner had not worked in the corporation is a question which is required to be decided by the corporation. If the respondent corporation decides not to pay the petitioner his salary allowances for the period for which the and if the petitioner feels aggrieved by any such decision, it shall remain open to the petitioner to take recourse to enforce. At the same time, the respondent corporation shall remain at liberty to take such action if it may otherwise with the respondent corporation. So another contention is that from 2002 to 2009, you did not allow me to join. This cannot be, cannot fall within the area of the principal manner, no work, no pay. It is not that I was terminated and then I was reinstated by court order and all manner. So during that period, the court directed them to take a decision and they have taken a decision manner, simply saying that they
After you had submitted the VRS, what happened?
they rejected me. That's why I filed first degree.
No, they rejected it. You submitted on 1910, 2002.
Yeah.
No, you submitted resignation,
Yes, ma'am. 1910. Yes.
1910. Handed over, taking over charge then. They said that acceptance will be subject to clearance of
Loan taken by the
loan taken. Then,
petitioner first some time to pay and then
30/08/2004, you withdrew the resignation.
Right.
Prior to 30/04,
Right.
was there any attempt by you to join in service? Did you approach the authority that
Yes.
since your resignation has not been accepted?
Possibly, no, madam. It was very correct, madam. 2002 to 2004, there was no. It started only from when I saw that they have not accepted my resignation. I mentioned, madam, I'm doing some a new business and all, madam. Your lordship can provide presumption that 2002 to 2004, my lord.
No, not presumption, these are factual,
Yes, correct.
whether you attended to do it.
Yes, going by the fact, my lord, 2002 to 2004, your lordship can make it. When they did not give me DRS, my lord, I had no option, I applied, I was getting back.
Hmm.
then-
Where is the letter for rejection of your application for VRS? Is it available?
That is mentioned, all these factual thing, my lord, I have not given, that all are mentioned in the TSL report, my lord.
No, but there must have been some communication, some order
Yes, my lord.
that is not available here.
That is not mentioned, but that is mentioned in the judgment.
Yes.
In the judgment, my lord, all these facts and dates are clearly mentioned, my lord. I am not read in full, my lord.
Yes.
At this stage, my lord, I have an instruction, my lord. If that period, my lord, they pay some, when they take a decision. That's something that also, my lord, for otherwise, my lord. As far as secretary appeal, they have not, are given legal notice also, they have not. Till date, my lord,
Appeal is pending.
I have given legal notice and everything, twice, that, my lord, they have not done anything with it. Now reminding that if secretary appeal will be, my lord.
Yes. Are you supporting your case by any judgments or any authorities?
One judgment, yeah. In a proceeding, my lord, how the evidence has to be. The findings are restricted to be on.
Any judgments on the judicial review of such?
It is like that, it is on this one, 16 and 17. It's okay to judgment of basically, which is a FEMA case, my lord,
Hmm,
on judicial review. my lord.
yes.
I read the quoted part, my lord. Judicial review is not an appeal from the decision, but a review of the manner in which the decision is made. Part of judicial review is meant to ensure that the individual receives a fair treatment and not.
You're reading from which paragraph?
Page 9,
Okay.
page 8, my lord. I'm sorry, page 2 is 16 and 17, I'm reading. my lord.
Okay.
The quotation is there, my lord.
Yes.
The two informations are separate and distinct, though conceivably in some cases both may present. There may be cases of no evidence, even where the government is acting bona fide. The state information may also exist where the government is acting mala fide. And in that case, the conclusion of the government, not supported by any evidence, may be the result of mala fide. But that doesn't mean that if it is true that there is no evidence to support the conclusion of the government, the rate of security will not issue without further proof of mala fide. That is why we are not prepared to accept the learned attorney in this argument that if no mala fide are alleged against the appellant in the present case, no rate of security can be issued. That takes us to the merit of the respondent's protection that the conclusion of the appellant that the third charge framed against the respondent has been proved is based on no evidence. The learned attorney general has placed before us that in dealing with the question, we ought to bear in mind the fact that the appellant is acting with the determination to root out corruption, and so it is shown that the view taken by the appellant is the reasonable possible view. This court should not be in appeal over the decision taken and seek to decide whether this court would have taken the same view or not. This concession is no doubt absolutely sound. The only test which we can legitimately apply in dealing with the part of the respondent case is there any evidence on which a finding can be made against the respondent that the charge number 3 was proved against him? Next, in jurisdiction under 226 on such a plea, the High Court cannot consider the question about the sufficiency or adequacy of evidence in support of the particular conclusion. That is a matter which is within the competence of the authority which deals with the question. But the High Court can and must inquire whether there is any evidence at all in support of the implied conclusion. In other words, if the whole of the evidence laid in the inquiry is accepted as true, does the conclusion follow that the charge in question is true against the respondent. This approach will avoid weighing the evidence. It will take the evidence as it stands and only examine whether on that evidence legally influence conclusion follows or not. Applying this test, we are inclined to hold that the respondent's evidence is well founded because in our opinion, the finding which is implicit in the appellant order dismissing the respondent that the charge is proved against him is based on no evidence. Exactly, I am submitting because lordship that there is no evidence to the charges. Apart from cases of no evidence, this court has also indicated that judicial review can be resorted to. However, the scope of judicial review in such cases is limited. In this category, in India, the three judge of this court rule the judicial review is not an exit from the distance principle. It meant to ensure that the individual receives the fair treatment and not to ensure that the conclusion with authority is necessarily correct in the eye of the court. The court tribunal in its power of judicial review does not act as an appeals authority. It does not reappreciate the evidence. The court held that the feeling is one. Judicial review is not an appeal from the decision, but a review of the matter in which the decision is made. Our judicial review is made to ensure that the individual receives the fair treatment and not to ensure that the conclusion of the authority is necessarily correct in the eye of law. When an inquiry is concluded on charges of misconduct by a public servant, the court tribunal is concerned to determine whether the inquiry was held by complainant officer or where rules of natural justice were complied. Whether the findings and conclusions are based on some evidence, the authority entrusted with the power to hold an inquiry has jurisdiction, power and authority to reach the findings on some evidence. But the finding must be based on some evidence. Neither the technical rules of evidence nor the proof of fact or evidence as defined therein apply to the discipline of the case. When authority accepts the evidence and conclusion which is support therefore, the discipline authority is entitled to hold that the delegate officer is guilty of the fact. The court tribunal in its power of judicial review does not act as an appeals authority to reassess the evidence and to arrive at its answer. The court tribunal may interfere where the authority can proceed with the delivery officer in a manner inconsistent with the rules of natural justice or in violation of the state rule, deciding more than inquiry, or where the conclusion or finding reached by the disciplinary authority is based on no evidence. If the conclusion of the finding is such as no reasonable person would have ever reached, the court tribunal may interfere in the conclusion of the finding and more the relief so as to take an appropriate action. The disciplinary authority is the sole judge of facts. Where appeal is presented, the appeal authority has co-extensive power to reappreciate the evidence or the nature of punishment. The disciplinary authority restricts proof of legal evidence and findings on that evidence are not relevant. Educational evidence or reliability evidence cannot be permitted to be canvassed before the court tribunal. In financial cases, if the conclusion upon consideration of the evidence reached by the disciplinary authority is adverse or suffers from pattern errors of face of the record or based on no evidence at all, read assured. So this is about the guideline of judicial review matter. So my submission is that there was no evidence before the authorities to sustain the charges on the basis of the facts. And those facts that I have placed before your lordship, these are not ever discussed in the inquiry report and in the order of facts. Therefore, the appeal order is not pending.
But you did not join for a particular period after your resignation was not accepted.
Yes, ma'am.
That is admitted. There is no dispute.
No, during that period, my as your lordship on 19/10/2002, I tendered the resignation. They have released me. They have said they have not said that your resignation is accepted. They said you pay the
Subject to legal.
my future life in the corporation. They will always deduct. So that was not a difficulty. Then I say that I am
Keeping in view the charges. There are three charges. Number one, you did not attend duties. Number two, you continued business. Number three, housing loan not refunded. The housing loan, for the time being, will take it that it has been recovered. That leaves only two charges. You did not attend the duties. Now, your case is that you did not attend because they did not allow you to join. Now that not allowing you to join stage came only after they rejected your VRS.
It's
Prior to VRS, when you came to know that your resignation was not accepted or will be accepted subject to clearing of the dues, you did not attempt to join back.
no, man, yes, absolutely very correct. I submitted resignation.
Private physician,
Fairness, yes,
yes.
going by this data also, you have responded correctly, madam. But it is not that I have not, they have not called me, that no, resignation is they can come and join.
They
said
will
that
not call you.
Pay that amount.
No, they will not call you. Why will they call you? You are an employee, you have been appointed on a particular date and you retire on a particular date. You are required to join. If you don't join, you are required to submit your leave application or whatever procedure is to be followed. You can't say that they will invite you to join back again.
No, not that. What I'm saying.
After you are intimated that your resignation will be accepted only upon clearance of the dues. The meaning thereby that you have not been discharged, you have not been released from service. You're still an employee.
I have got to, but for that period from 2002 to full DRS matter, there are two perceptions, whether I am entitled for any salary for that period or whether.
Salary will come later.
Okay, whether I have done this conduct.
No. First thing is whether you are required to join back or not. What does the rule say?
Yes, ma'am. Yes, ma'am.
If there is a circular OM or any set of rules where it says that pending acceptance, you are not required to join. Once you submit your resignation, you have voluntarily submitted your resignation. Having done that, you are now not required to go and join the duty.
Right.
Your dues will be calculated pursuant to the resignation being accepted. Now, the resignation was not accepted on the ground that there is a housing loan
No, madam.
due.
No, it is not accepted on this. The Lordship, can you see the language, madam? Where it is accepted the resignation made subject to housing loan. They have never said that we don't accept your resignation.
Subject to housing loan means what?
If I pay the house, then it is accepted.
That you have to pay, which was not paid.
Was not paid, madam. My money is what is here, madam. So
We are not on that. We are trying to understand the sequence of the facts.
Exactly.
So you submitted the resignation. Then the order was that we will accept it subject to clearance of the housing loan. It was open for you to get the money, give it to them.
Well.
And take the clearance certificate and you are free.
Well.
That was not done. For whatever reasons, you had hardships, financial difficulties, health problem, this problem. Fact remains that your order of release was not issued because there was a housing loan pending. Your resignation was not accepted. Right? Then you submitted a voluntary retirement, VRS, which was also rejected. Now, subsequently, by orders of the board, etc., you were taken back into service. But can you say that from the date you submitted the resignation till the date you join, at least pursuant to the being intimated that your resignation will be subject to clearance of the housing dues, can you say that you are not allowed to join? That defense that you are not allowed to join, perhaps, is not available to you for that period.
Well, and I understood, the Lordship.
Subject to such clarification coming.
So, sir, this aspect of the concern matter, Learned Judge has clearly said that I should be considered to be inconvenient. Considering all these facts, matter, that there is a finding to that extent which remains undebated and is holding the treatment. This is one. Number two, matter, on fact of the date your Lordship is saying, that there was no clear letter to the petitioner from the corporation that your resignation is not accepted, you resume duty or whatever. Only said that only some dilemma was there whether I was when I pay back the loan amount.
Let us go through the single judge's order again.
Well, that will be page 22, madam.
Yes.
If I read it as a whole, madam, that will be all text and narrative there, madam.
You take us to the observation of the single judge that you.
So, this fact part, Madam Lordship, can you see page 23? With one paragraph I read, Madam.
Yes,
23, 1 minute.
yes.
While working in the rank of deputy manager in Hindustan Petroleum Corporation, the company registered 1999. The petitioner is this corporation is informing the petitioner that he was on lateral basis reassigned and posted as executive operational officer at Kolkata. And that his reassignment can be effective from the date he assumed charge the executive operational officer. Following to the order of his posting at Kolkata, the petitioner submitted on 19/10/2002 address to the chief installation manager Kolkata terminal of the state corporation a letter tendering his resignation from service with immediate effect. By letter dated 18/6/2003, the respondent corporation informed the petitioner that acceptance of the petitioner's resignation and his release from employment would be allowed by the respondent corporation only after the due quantified in the state letter, which is amounted to rupees 4,60,000 and ordinary. With penal interest 12%. On 14/7/2004, the respondent corporation floated a VRS policy considering himself a person covered by the state scheme and eligible to opt VRS. The petitioner submitted on 30/8/2008 an application withdrawing his resignation and requesting the respondent corporation to consider his case under the state scheme. By letter to the respondent corporation informed the petitioner that his application seeking benefit of VRS was not acceptable to the respondent corporation. This order dated 12/2, whereby the petitioner declared for allowing him to avail the benefit of VRS has been declined, came to be challenged by the petitioner in the great petition, which gave rise to WPC number 20. During pendency, the state great petition, the Respondent Corporation issued a magnitude number 22 seeking decree of recovery of amount of fuel lakh in court matter in prayer. Before, however, the state suit was executed, the petitioner on 29/11/2006 submitted letter to the film manager president of Kolkata stating to the effect, it should be understood that the resignation had not been accepted by the management. He was facing great difficulty and therefore he was withdrawing his resignation with immediate effect and reporting duty. Closely following his letter dated 12, the petitioner submitted his joining response to addressed to the general manager principal, undertaking to withdraw the repetition transfer mentioned, but the petitioner was not allowed to join his duty. The state petition was eventually disposed of on the same having been withdrawn by the petitioner, and on 10/1/2007 itself, the petitioner submitted an application addressed to the general manager requesting him to allow the petitioner to join duty. As the respondent corporation did not allow the petitioner to join the duty, the petitioner is now before the court. This is now stand of the corporation I have read matter. And paragraph 5 matter. Otherwise, I have read matter, only paragraph 5 matter. From a minute reading of what the personal manual contains with regard to the resignation by the respondent corporation, and it becomes clear that according to the terms and conditions of the employment which the respondent corporation has with its employee, the resignation tendered by the employee needs to be accepted by the company authority before the employee resignation from the court becomes effective. It is otherwise also well settled principle that the resignation tendered by an employee is ineffective until and unless the same is expressed by the authority concerned. In the present case, the letter registered to aforementioned which the respondent corporation had issued makes it clear that the corporation refused to accept the resignation until the time that due as has been quantified by the corporation or state. The respondent corporation has not been able to place any material on record to show that the petitioner resignation was accepted by the corporation. Though the petitioner in a letter dated confirmation had stated to the effect that he was resigning with immediate effect, the fact remains that his resignation, in order to become effective, required acceptance by the respondent corporation. Such acceptance having not been recorded to the respondent corporation, the petitioner's resignation from service never came to effect. In such circumstance, when the petitioner submitted by his letter dated that he was withdrawing his resignation and immediate effect, and the respondent corporation ought to have allowed the petitioner to report for a duty. Rest is not under last paragraph I said.
This is what I was saying. It is evident from the judgment also. That until and unless it is accepted. it is deemed to be not accepted. If it is not accepted, then you are deemed to be in service. If you are deemed to be in
That's why
service,
paragraph 6 says, my lord, petitioner has remained in service without responsibility.
till date. So, but you did not join your duties. There was no application for leave.
No, here it is also being recorded that after VRS was declined, my lord, as you also pointed out, my lord. After VRS, my lord, it is not my fault, my lord. They are not allowing me to join.
No, after VRS, okay.
After VRS, after the judgment,
After VRS, all right.
yes, yes.
What What I'm saying is immediately after you are informed that resignation is subject to release of the dues, you are required to, you ought to have given.
Therefore, my lord, everything is clear, my lord. Now you also will consider only this, that having tendered the resignation, having been released, when I was informed that you have to pay, it is subject to that.
That is for you to submit. You have to argue on the basis of
Yes, ma'am.
legal formulation, legal.
That is submitting, my lord.
Hmm.
So that period to that period, my lord. When my resignation, people say that until another 58 is amount will not,
Hmm.
that amounts to refusal.
Hmm.
Then, my lord, VRS rejected, my lord. Till that period, my lord, it may not be taken as a misconduct, my lord. Because it is not that I have dropped the letter and went, my lord. The authorities knew everything. I have gone with the procedure. They had certain views. Views was the problem, my lord. There was no complete letter that no, your unnecessary action, you immediately come and join in the interest of whatever. I was not joining because I could have arranged the money, maybe that is the reason, ma'am.
All right.
So my only study, that part, my lord, it cannot be treated as a misconduct, ma'am.
If the rules say it is misconduct, it is misconduct. You have to tell us that undue absence from the rules is not misconduct.
And you,
Unauthorized absence will not be treated as misconduct under the rules.
unauthorized, Lordship, can you say, I am speaking, my lord, unauthorized, means, my lord, yes, I have read the photo, my lord, handing over, taking over, ma'am. I have duly been released by the.
Mr. Counsel, you have to understand one thing. You are an employee. Your entry into the service begins with the appointment order. Exit with the superannuation, resignation. Until then, your relationship between you and the employer exists. So there is a set of rules, there are a set of rules of how you should function, what you should do. Supposing you don't want to attend duties, you are not available, then you are required to make applications seeking leave or whatever procedure is applicable. Now, having not been done, whether that is to be considered as misconduct or not, is to be defined, is to be looked into the rules. The rules will have to say so. Do you have the rules here?
Also, the fact, my lord.
Are the rules here?
Rules, no, that is not in the PD, my lord.
Not in the pleading.
Rules always says about misconduct. And whether this
See,
this part is.
assuming that part, assuming, we have not come to a conclusion, assuming that particular part where you submitted your resignation, you were informed it is subject to clearance of the housing rule, these that you did not join. Whether that will be misconduct or not is subject to what the rules say.
Right.
Assuming you continued some business during that period. Whether it can be construed to be a misconduct again, that you have entered into a business relationship without proper permission from the authorities concerned while you were in service. Now, it is with, we are giving up the third allegation that regarding the housing rule. These two, you will have to show us that the evidence on record does not support the case, does not support the allegations.
The stand of the corporation before the single judge. there was a-
Before the single judge is that you are no longer there. But single judge has arrived at a finding saying that your resignation was never given effect to.
Correct.
So the stand of the authority is overruled by the findings of the single judge.
Exactly.
Now the single judge findings have been upheld by a division bench, SLP dismissed, so it has become final. So the finding is that you are in service.
Right.
Now, if you are in service, you did not attend your duties. No application, whether it amounts to misconduct.
So that is only the thing. But 2004, my lord, in a peculiar set of my lord,
No,
Yes.
subsequent we agree, subsequent you are not allowed to join, but had it been a case that you are never allowed to join, then perhaps prima facie, it is a case of no evidence. Then charge one goes. And consequently charge two, because you are not allowed to join, you are not considered to be an employee. But the stand of the department was overruled by the learned single judge with the finding saying that you were deemed to be in service. Now, in that context, is for you to submit before the court that there was no evidence to support that allegation also. You get my point?
well, I get it.
Yes.
You're actually saying that 2004, my lord.
We'll tell you the exact date. You submitted resignation on 19/10/2002.
Exactly, sir.
So thereafter handing over, taking over in 22/10. So from 22/10/2002, according to you, you are no longer in service. This resignation came, the intimation came in 18/6/2003,
My lord.
which is what? 6 months beyond, almost 6-7 months.
So this part is not my unauthorized agreement.
That is what we are saying. Until and unless your resignation is approved, you did not go in appeal against the learned single judge, which is finding.
So that is, I'm taking support of that, my lord.
No, therefore, if you are taking support, then your absence from 22/10/2003 to 18/6 will be considered to be unauthorized.
No, my lord. Lordship, can you see, when I duly relieved, and first time I intimated by 18.
You may have been released, you have released from that post. Why don't you realize that? You are handing over charge with regard to a post.
Right.
But your status as an employee, the resignation which you submitted was rejected on 18/6. 18/6/2003. Then in 38/2004, you withdrew the resignation, submitted the VRS.
This
So,
part,
so from 22/10, or let us say from 22/10 to 2002 to 18/6/2003, and from 18/6/2003 to 38/2004,
Right.
you were not in service. Whether it amounts to misconduct. There was no application from your side that having rejected my resignation, having rejected my VRS, allow me to join.
my lord, that 18/6/2003, my lord, that, my lord, my humble submission I'm telling, my lord, that, it doesn't say that your resignation is rejected, my lord. And I'm, just say that
It says subject to.
Lordship,
That subject to means the day you clear the housing dues,
this letter, it is, it is not with me, my lord, it is with them, my lord, that letter, wording,
we'll see that, we'll see
See
the
that.
wording.
whether that amounts to rejection and that compel me to file.
We do not know that, that will be your interpretation.
That is being mentioned in the judgment that, I mentioned.
So judgment, the finding of the learned single judge is that you are in service.
I will,
That's right. So if you are in service, you're bound to attend to your duties.
Learned Single Judge also said that, my lord, for this period, that they have not allowed me to join since 92, and they should consider for 7 or so months.
That has been left to the authorities.
But the authority has decided, but if you order saying that you're not taking it. And one thing, my lord, lordship, we consider, my
In
lord,
other words, there is no finding of the learned single judge whether you are entitled to that period for salary or
or
not.
consider.
Or considering, yes.
Now, we have come because that was possibly approved. That what will happen? But no work, no pay will not come. No work, no pay comes when I was terminated, then by virtue of court or terminal order, I was, that period I have not worked. And here, my lord, anything is clearly held that I remain in service. So therefore, that period I must get something, my lord, at least.
Your concept of, we are not able to accept, your
My,
remaining in service is with regard to your status as an employee. Whether you rendered service or not, it's a matter of record.
yes, I have not. Because
See, if you have not,
substantially they are not allowed me to join.
that is what I'm saying, that not allowing you to join is after a particular date. Before that, there was no rejection, there was no offer by you that I want to join because you've not accepted my resignation.
First communication that came from the authority 18/6/2003. That from that only I get some gesture that authority
That
has made it
unfortunately,
conditional.
that unfortunately is not a part of the paperwork.
That is conditional. If your lordship goes by it, that is conditional.
Is it
Prior to that,
it's a part of the paperwork? Is it available here?
no, no, I possibly it will be- maybe there is a requirement.
Yes, Mr. Sharma,
Lordship may,
do you have the reports?
yes, sir. Lordship may kindly turn to paragraph 2, Lordship.
Hmm.
The facts are stated there
Paragraph 2 of,
on the repetition.
yes,
I'm reading it out.
yes.
That the petitioner is a being from REC picture. He was initially appointed as officer KD in the Hindustan Petroleum Corporation Limited Jail after HPCL on 19/10/1991 and he was posted at Guwahati. Subsequently, he was assigned as an officer on 0/11/1991. In 1992, he was transferred to Barauni with promotion and back to Guwahati and thereafter to Kolkata on 4/9/2002. However, due to his personal problems, he had committed his resignation while he was at Kolkata. The said resignation dated 19/10/2002 was kept pending and ultimately by the communication dated 18/6/2003, the HPCL had informed the petitioner that his resignation could be accepted only on clearance of certain bills amounting to rupees 4,62,974 with penal interest at 12%. Paragraph 3. That subsequently on introduction of a voluntary retirement scheme VRS, the petitioner had withdrawn the resignation and opted for voluntary retirement by submitting an application dated 28/2004. However, the said application was rejected by HPCL on 21/9/2004. Paragraph 4. That against the aforesaid order dated 21/9/2004 of rejection by the HPCL, the petitioner had initially filed a writ petition in this honorable court in WBC number 7022 of 2005. It is pertinent to mention that at the same time corporation had instituted a money should be MS number 87 of 2007 before civil judge Kamrup for recovery of an amount of rupees 12,91,856.22 with interest. The said money should be still pending. Paragraph 5 also. That your petitioner says that he was issued a letter dated 29/11/2006 to the HPCL stating that since his resignation could not be accepted on the basis of rejection of his offer for voluntary retirement, he was withdrawing his resignation and reporting his duty. After issuance of such letter, there was a verbal assurance that he would be allowed to join on the condition that the pending WBC number 7022 of 2005 was withdrawn. Accordingly, the said petition was withdrawn on 10/1/2007 with liberty. However, contrary to such assurance, the petitioner was not allowed to join. That means, Lordship, since 2000 till 2006, Lordship, 29/11/2006, he was not of the view that he needs to join the service force. And he even instituted a case, Lordship, challenging the rejection of his.
Yeah, just a passing thought. Assuming he wants to join, where will he join? He had already resigned. He had handed over the charge. You did not dispute that. Now, if he wants to join, where will he join? Who does he report to?
Lordship,
Have you informed him about that?
yes, Lordship, it's in the record. Not about that, Lordship, but with regard to the payment of that amount, Lordship.
No, so what will be the status of the employee? He has resigned. You say will not accept until the dues are cleared. Now the dues could have been very well cleared from his retirement benefits or gratuity or whatever is there. Did you inform him that within certain such time, if you don't pay, we will adjust it against the dues available to him? You kept it pending. Now the man has to survive. So what does he do? He finds a way to earn money to feed himself and his family.
That question of it, there is one affidavit filed by us, okay?
Yes.
Page 176, okay?
Yes.
I am reading from the second paragraph. While your resignation is put for consideration by the appropriate authority, please be advised that acceptance of your resignation is subject inter alia to: number one, there will be no disciplinary vigilance proceeding under process or complete against you, and a clearance to that effect is given by the vigilance department. Clearing all outstanding dues of the corporation, the amounts due from you to the corporation will be declared separately. Your vacating company accommodation immediately, if provided by the corporation, and handing over vacant and peaceful possession thereof to the competent authority appointed for this purpose. Your handing over to your supervisor charge of the documents, papers, and other properties such as this office keys, identity badge card, etc., belonging to the corporation. Please note that your release from the services of the corporation is subject to a letter of release to be issued by the corporation. Till such time, you shall continue to be an employee of the corporation and attend your assignments as are entrusted to you by your immediate supervisor. So that was the instruction given to him, Lord, because he did not done.
But
Immediate supervisor, Lord, he was required to at least
what is the reply affidavit to that?
reply.
This is for which paragraph? Paragraph 11.
Paragraph 11.
Sir, page 127,
Hmm.
the inquiry, I took the stand that this letter was never served. It is mentioned in the general order, 127. Then that presumption has been drawn that it must have been served. In the inquiry to the email.
Reply, paragraph 12, not to the reply, paragraph 11.
You did not mention this in your affidavit reply, you never received it. In the WS, did you take a stand?
You know,
Where is the WS?
look at the W's. These are page 52, not. Page 52.
In charge, it was not mentioned by that.
Huh?
That's why, in charge, memo.
No, you mentioned that you took a stand that this letter was never served.
In the employee proceeding management, there is a project that we can look at. That page, it has been mentioned in the review order, matter 127 matter. In the career order, it is mentioned, matter. Last paragraph,
Where? In
127 matter,
127.
in the order of penalty matter by the review of the.
Where?
Last paragraph, matter, it is also found that my data transfer of each one borrower was advised in writing to continue with the service. If the time is issued letter of release and transfer. However, it found that the each one borrower, despite the regulation, did not attend the state exit interview nor attended the duty advice. I find that the each borrower during the course of inquiry proceeding contended that he did not receive the letter dated 8/11/2002. And next page, madam, it says that as it appears that he felt intentionally denied, madam. It's a presumption, madam.
You use presumption because you received all other letters.
Yes, madam. So intentionally, might have received intentionally denied, madam, that should be some evidence.
How did you send the letter to him? What record do you have?
If paragraph 11 months more also, there in the analysis, you do first, the start this.
Karen?
Paragraph 11 of my page 154. That with regard to the statements made in paragraph 2 of the repetition, the deponent beg to state that the contents of this paragraph with regard to the running of the services of the corporation by the petitioner, his career progression and his reassignment which are the matters of record, hence need no specific reply. With regard to resignation of the petitioner from the services of the corporation, it is submitted that while it remains a fact that the petitioner had resigned from the services of the respondents by the resignation letter dated 19/10/2002, the same could not be considered as there were payables accruing in the name of the petitioner, and as per the rules, no resignations under such circumstances was liable to be accepted. It is absolutely incorrect that, and hence specifically denied that resignation of the petitioner was kept pending, and he was informed by communication dated 18/6/2003 that his resignation could not be accepted subject to clearance of certain things. The petitioner is put to spectacle for making such submission. It is submitted that the respondent corporation issued to the petitioner formal acknowledgement letter on receipt of resignation dated 11/2002, informing the petitioner as per the policy of the corporation to attend the exit interview on 30/11/2002, which the petitioner did not attend. It is submitted that in the same letter dated 8/11/2002, the petitioner was clearly communicated that acceptance of his resignation is subject to clearance of all outstanding dues of the corporation, and his release from the services of the corporation is subject to a letter of release to be issued to him by the corporation, and till such time the petitioner was advised to continue to be an employee of the corporation and attend such assemblies as are entrusted to him by his immediate supervisor. However, petitioner left the place of working without taking any approval of leave from his supervisor. This act of petitioner itself is a violation of the rules of resignation policy of the corporation, wherein the employee should not leave station/working place until employee is issued a letter of release from the service of the corporation. It is submitted that management witness number 2 in his examination with chief during the course of inquiry proceedings confirmed through documentary evidence, that is copy of registered AD and courier receipt, that the petitioner was forwarded the copy of the letter dated 8/11/2002, wherein it was clearly mentioned that acceptance of resignation submitted the petitioner is subject to clearance of use of the corporation. That was the stand taken. It was to raise that post. And he was to attend an exit interview, she did not attend.
In the letter at page 176, there's no mention of exit interview. Only thing is that you are to have a meeting with so and so. No, it was not specifically mentioned. Where are the rules? Where are the rules?
This letter was issued on 28th November, Lordship, and the interview was to be held on 30th. The rules, Lordship, actually, even I don't have the rules, but in the so-called notice, Lordship, the rules will be put under which.
You give us a set of rules. We need to go through the rules. You get a set of rules. You show us the relevant provisions in the rules.
I have it, Lordship.
Complete rules, not the extract. Complete
No,
rules.
something, yeah, regarding discipline proceeding.
You tell us,
Lordship, at present, I don't have it, Lordship.
what are you handing over to us?
No, this is my copy, I just. Fine.
You get a copy properly and hand it over to us.
Lordship.
Tell us the relevant provisions of the rules. Yes, Mr. Nair. What's it?
Also, one more thing, although my senior has said that in the inquiry, because these things have happened or has happened, but not he is not telling the inquiry not. And the so-called notice was also not put to challenge. Only the penalty order is being put to challenge. And we expect is by going to take years, but that is the.
What are the misconducts for which you have initiated proceedings?
Almost lots of the articles of charges.
No, from the rules. How is misconduct defined?
Part to disciplinary appeal misconduct.
So it's number 8 and number 25.
8, 10, 22 and 31 losses. There are 42 losses.
8, 10.
8, 10. There are 42 losses.
Page 42 of
Of the litigation law.
Along with the charges.
42. Yes,
This is the rule which was alleged.
8, 10, 22, and 31.
Yes, Lord, this was alleged to be violated by.
And then charge 2,
That is. And misconduct, 22, 25, and 31.
35, 25 is not mentioned.
22, 25, 30.
Hmm? Okay, 22, 25, 30. Yes,
The charges that were basically framed.
the inquiry report is here.
Yes, Lordship. But Lordship, also there is the written statement once, Lordship.
Yes.
Going to the inquiry.
Where is the written statement?
It's a page, it starts at page 52, Lordship. The shorter one, I will read it only, Lordship. That's
This is a written statement for the charges or after the inquiry.
No, Lordship, after the show cause notice, he submitted this written statement. The show cause notice was done 15/4/2009, and he submitted this written statement on 18/5/2009. So received on 19th.
Yes.
Lordship, may kindly remember this, I am reading it, Lordship. That is, sir, in your letter dated 11/5/2009.
But this is, page 52 is in response to letter dated 15/5. 15/5.
15 April, Lordship. Page
It says 15.
36,
So see the reference in page 52.
Lordship. The reference number matches what this number. Doesn't match what this 15. Date, Lordship, the month doesn't match.
Yes.
That's in your letter dated 11/5/2009, it was categorically stated that all the annexes to the memorandum have been annexed with the memorandum and sent to register post on 16/4/2009. Laying the documents into grantor, state contention is far away from the fact. The memorandum received in a global measuring about 12 centimeters to 5 centimeter sizes, which cannot accommodate the voluminous document. From the above, it is clear that the state annexes as cited in Annex 3 of the memorandum as item number 1 to 10, not sent along with the memorandum. Yes, sir. I am submitting the different statement article wise in addition to my letter dated 8/5/2009 for time variable and judicial recently. I once again do not accept the allegations as cited in the subject memorandum. Yes, sir. I like to submit against the allegation by Article 1 that as alleged, I was on unauthorized absence. In this connection, it is submitted that in my letter of resignation, I have clearly submitted the reason and
circumstances as to why I tendered my resignation and also the address where I found I would be available and so agreed to pay 1 month notice pay and then I have to return to my Guwahati joint address. I am confident that the corporation has given due notice to the residents and also accepted the fact since a lot of correspondence made with me by the corporation authorities in the given address of Guwahati joint. Hence, it cannot be termed as unauthorized action. And it is also revealed in principle that the resignation letter has been accepted and put up for consideration subject to certain clarification and permission. However, from the suspension letter dated 13/4/2009, it is very clearly established that I am still an employee of the corporation. But sir, during the last almost 6.5 years, I was never informed about the same fact and accordingly I was never asked/advised to join duty. Although time and again I approached the corporation through several submissions to allow me to resume duties, but no communication was received by me in the same aspect. From the above, it is very clear that the corporation on principle agreed to accept the resignation. Hence, the question of unauthorized absence now raised after a lapse of almost 6.5 years is not enabled and as such. Which the resignation of this credentials. This submission was with in his written statement. He himself admitted that he did not he did not oppose the authorities within that 6.5 years. And the fact that he instituted a case challenging the order of rejecting his voluntary retirement was being challenged by him. Also, it points out that he was not willing to join his service. Article 2 lawsuit. In this regard, the allegation under Article 2 is stated that I started my own business, own IT business while continuing in the service without previous permission of the competent authority of the corporation as admitted in my letter dated 29/4/2004. So it was submitted that I tendered my resignation from the service with effect from 19/10/2002 and thereafter on 15/7/2004. I submitted a letter withdrawing the state letter of resignation and allowing me to leave on voluntary retirement scheme, to which the authority concerned estimated that BLS cannot be granted since I have already resigned from service. From the above, it is clear that the principle of authority.
Where are those letters of informing him that his resignation will be subject to clearance? It is in that 154. Is it enclosed to your affidavit? That letter?
154.
Sorry, 176. 8181.
That was one of them, doctor. And there were, he himself said his lordship, there were several communications and he himself attended the office lordship, but he did not pay the dues. Nor he reported to his superior authority lordship regarding his rejoining lordship. Lordship is reading page 176.
176, yes.
May I read it again, Lord?
No, you don't have to. What we want to know is whether this is the letter which is referred to, whether the petitioner saying that he was informed that his acceptance of resignation will be subject to clearance of the housing loan.
No.
Is this the letter or there is any other letter?
There are other letters
Which was that letter?
in the record, Lordship.
No, flag it. You flag it and make a list of the documents.
Lordship, in fact, in paragraph 2, the petitioner has admitted that on 18/6/2003,
Paragraph 2 of
paragraph 2 of the petition, Lordship.
yes.
Lordship will turn to page number 4, the third line. Lordship. The said resignation dated 19/10/2002 was kept pending and ultimately by the communication dated 18/6/2003, the HPCL had informed the petitioner that his resignation could not be accepted only on clearance of certain dues amounting to this 4,67,940.74 with penal interest. So he had accepted that. Lordship.
There's no question of him not accepting, it's a matter of fact. The question is, in the communication that you issued to him, we want to see what is the tenor of the communication, what was there.
Page 126, Madam, there has been quoted. 126. In the order of management. Only relevant part has been quoted. So that will be there in the report.
Yes, good.
Second paragraph says that here is the option.
This is on 18 June. Yes.
Lordship, in 18/6/2003 letter, Lordship, we have referred to that 82 letter, Lordship, which are in annexure 1 in the affidavit in objection. But that was not objected to, Lordship. That receipt or not non-receipt.
Now, he says he has filed an appeal has not been disposed of. Why? Before the appellate authority,
Appeal was not.
why?
That was, then the proceedings were initiated here, so why not those proceedings started?
Okay.
Lordship, the fact that he wanted to join the corporation, that was raised by him only in 2006, Lordship, after 19/10/2002, Lordship, when he submitted the resignation. After that, Lordship, he never approached the authority seeking his reverting that or resuming the duties, but that was not. And that's been reflected in the order, Lordship.
Have you gone through the judgment referred by Mr. Counsel?
Lordship, that was to 11 because the inquiry proceedings have not been quickly challenged.
This is Vishwanath Bhattacharya.
Here to verify. Even the fact that he was knowing, sorry, Manoj, just one clarification. The fact that he was knowing that his resignation was not accepted, he should join, right? That 18/6/2003 letter, Manoj, is reflected in an order, in a writ petition filed by him. 3/30/2007, the order is 3/4/2008. Manoj would find that at page 23, Manoj.
Yes. Page 23.
23, Manoj. That is relevant 22, it starts. Relevant 23,
23 is the part of the judgment.
Lordship.
Yes.
Manoj, para 2(1). While working in so and so, a company registered on the so and so letter was issued on so and so by the so and so, informing the developer he was on letter is reassigned and posted as so and so. And that his reassignment shall be effective from the date he assumes charge. Following the order of his posting to Calcutta as indicated here in above, the petitioner submitted on 10/2002, addressed to the so and so. By the said letter, a letter tendering his resignation from service by immediate effect. By letter dated 18/6/2003, the respondent corporation informed the petition that acceptance of the petitioner's resignation and his release from employment would be allowed by the so and so only after the dues quantified the said letter was amounted to so and so, so and so, so and so. Now, this 18/6/2003 letter contains a reference to my lord that 8/11/2002, immediately which was given to him. He never disputed this position. So, my lord, in spite of knowing that his resignation was not accepted, he continued to remain in it. Then he writes a letter to us that, see, I am now doing a business. That's why the second and the third charges have come up.
Yes.
And paragraph 5, page 25, my lord. This honorable court noticed that he is an employee. And his resignation never came into effect. And the last line, my lord, page 26. At the same time, the respondent corporation shall also remain at liberty to take such action, disciplinary or otherwise, which the correspondent corporation may be entitled to take on the ground that the petitioner, after submitting his resignation, remained away from the post even without his resignation having been accepted by the competent authority of the respondent corporation. But after this finding, charge number 1 is there. And he has not brought on record anything. Now he cannot say that I did not know, I had given up, I had done this. Well, if he, in terms of his written statement, says that my resignation stood accepted, well, there is no need for my lord to go into this matter.
What is the status of an employee after he filed the resignation till it is accepted?
My lord, he will continue to be an employee.
That is correct, but
He cannot leave the post, my lord. He cannot leave. My lord, there would be different circumstances, how it is now. There may be a resignation which will not require any acceptance from anybody. I giving a resignation, my lord, that will automatically come into effect. Then there would be a resignation which, my lord, must be accepted by the authorities. And this falls in the second category.
does your rules say anything about it? In terms of whether it is to be accepted or not?
Lordship. This being the, my lord, discipline and appeal rules. Maybe, my lord, that aspect may not be here.
Then where does one get it?
It might be in the,
You cannot sort of,
no, we cannot,
say that it is not accepted until.
No, but the general principle, my lord, remains. This honorable court has also accepted that.
No, subject to the rules being specific to that.
That-
You are certainly within your rights to say that unless the dues are cleared, we not accept.
Hmm.
But alternatively, you could have also put into notice that these are the dues available, we are adjusting it against the dues available from the company. If you do not clear it.
But my lord, one thing, when he went away, we immediately gave him this 8/11/2002.
Correct. I'm asking you, is there anywhere in the rules? Must be there. In
It's
some
not
position.
there, it will not be here, it would be in the other rules.
So have a look and.
I'll have to get that.
And give us the relevant portion of the rules.
But that I can get your lordship. And Lordship, one more thing. If I can just put it in a different perspective. What had happened here was he submitted his resignation, he moved away. And we treated that period as unauthorized absence. And there is no justifiable cause shown for that overstay or that unauthorized absence. And that, my lord, is also reflected after the proceedings of this court. My lord Justice Ansari's order, my lord, the last paragraph. Because he moved away from Calcutta. And he came to Guwahati. And then proceedings were started. Be that as it may, my lord, finally, the proceedings, my lord, would start. And my lord, the charges which were there, all the three charges, my lord,
So one thing led to the other. He submitted resignation, he did not attend office. You said we will not accept your resignation unless these are
that's
cleared,
that is the
etc.
end of the matter, my lord, for him.
So
No, he did one more
according
thing.
to the company, this is unauthorized absence because unless accepted, you ought to have joined. He not having joined, perhaps you also did not release his salary.
No,
So that salary not being released, he had no option but to fend for his family, started his business or whatever he wanted to do. And then finally, what is the third charge?
my lord, the third charge is the housing loan, my lord.
Housing. So housing loan as on date has been recovered.
No,
Or not recovered.
Hmm.
Still pending.
still pending. Because that housing loan did not occasion. my lord.
What happened to the money suit which was filed?
Lordship,
Some money suit was filed.
this was.
Dismissed.
Because they also
Dismissed for what? Non-prosecution.
Because they recovered the money, madam.
Recovered.
I can give the calculation, madam. They have recovered around 70 lakh from
What is the amount due?
5 lakh is not.
You calculate and tell us.
I can give
But
it.
my lord, if this order stands, that amount will not be due to him. my lord. And those amounts will not be due to him. If you- Otherwise,
Whether the housing loan which he had taken,
Lordship,
whether the dues in respect of that have been recovered or not.
that, my lord, if you can show, I'll be.
Page 60 has to be guaranteed. Page 60 is also gate, madam. That explains the situation.
Page 60.
60 of the receipt.
Yes.
We are reading, madam. These are the response to your letter number 22 with regard to the payment of housing loan disbursed to you amounting to rupees 3,92,000 was first to take equipment and 1,63,000 transfer for 6 to 8 installments during the year transfer and April transfer. As stated earlier, you did not submit payment receipt for 163.425, which was required to be submitted within 30 days from the date of disbursement.
This is asking you to refund it.
No, my lord, correction. Yes, sir. As you did not utilize the housing loan for the purchase of the flat, madam. A calculation is like this, my lord. As you kindly see, reported amount was 5,51,645. It is mentioned, my lord.
Yes.
Now, I paid here, my lord, it is mentioned that I have deposited 1,54,000. Second paragraph, last line, my lord. I have paid. So what remains is the 3,92,220.
Plus interest.
Interest is there. I'm coming with the final point, madam. Now, Lakshmi kindly see for by this amount, by this letter, only 1/3 salary is to be paid to me, 2/3 to be deducted. The salary which was paid to me was only 40,000. That is also part of the record, madam. Lakshmi kindly come to removal order, madam. Page 135, madam. And
Alright.
there are provision, my lord, even in the dismissal, my lord, they give 1 month salary,
Yes,
135, that is 41,000. As you actually got it, ma'am.
yes,
41,000, meaning the other matter from this date, that is 60, 8/3/2010, to the date of passing the June order matter. That is on matter,
Third of October.
3rd October matter. That will be around 19 months,
okay,
80,000 minus 19, it comes to matter around 15,58,000 award matter.
all right, you show us that provision,
This is not the period case, I did not, I also have my questions on that.
get it,
I'll get that. And the records, Malad, can I have it back? I can
Certainly.
simplex it and give it back.
yes, certainly. You have the report.
Next week.
Matter, but only one.
Can we close it or we have to keep it?
Watch it.
Do we close it or we?
Can we close matter?
Malad will only keep it for a day. Malad will keep it for only for a day. Malad, I'll just give those instructions.
All right,
And I want to show Malad from the charge sheet what it is.
134 doesn't calendar matter, 134. That my unauthorized assets have been considered from 2002 to 2009.
we agree with that, we pointed out that after the initial period, till you were informed, till your VRS was rejected.
No, but the charge, in the charge it is mentioned that I am absent from 19.
If the charge may not have been absolutely accurate. But to say that absolutely there is no evidence of you being in unauthorized evidence, it is for you to point out
23, the charge itself says 23/10/2002.
On what matter?
on
But the concluding period is that matter, that's why I am pointing out. Concluding period is till 1999.
heard both councils. Hearing remained inconclusive, list on. When did you get it?
Malad would have it, Malad. I think Malad can pregnant. Malad, can it be on Thursday, 17th is a Thursday, Malad. So I get some time to get it. 17th. 17th or 22nd, whenever my lord's born.
22nd.
22nd.
22nd. Let it be on 22nd.
Logic. I'll have those. Much of it.
I think item number 1.
Please look. My lord, FIR is 11. There is also a cross FIR. Filed by the wife of accused number 4 of this FIR.
This is the second bail. Second bail,
Second.
where is the earlier order?
Earlier, what is, I have the one also by, we are finding additional activity. Page 31.
Now you say charge sheet has been filed. So what remains now? You appear before the court.
What you may kindly call for the record and it should be taken by the sound of the court.
We are passing orders closing these matters. Requesting the trial court to examine your case and pass orders. Relying on the law laid down by the apex court in Siddharth and other cases. But Mr. M.I. Hussain. And the counsel to the petitioner also had Mr. P. Sharma under KPP. The state. This petition has been filed. By the petitioner. Apprehending arrest. How many petitioners?
5.
5 petitioners apprehending arrest. In connection with or book PS case number 32 of 2023 under section so and so so and so. So by FI dated 15/2/2023. It was alleged by the informant that the accused persons named in the FIR attacked the informant, her husband, brother-in-law, son, and nephew. And one Basid Ali, and seriously injured him. So it was further alleged that the mother-in-law of the informant was also assaulted, causing serious injury, and thereby and thereafter set her house on fire, leading to her death. Also, they say the fire was received and registered as Sorbo PS case number so and so under section so and so. During the course of investigation, the petitioners were required to appear before the investigating officer in connection with the investigation carried on. Stop apprehending arrest, they had approached this court. So earlier, petitioners had filed approached this court by AB number 741 of 2023. Stop this court by order dated 27/04/2023. Upon due consideration of the materials available in the CD, rejected the prayer of for bail, anticipatory bail, as prayed for by the petitioners. Following the rejection of the earlier bail petition, the present anticipatory bail application has been filed. Mr. B. Sharma, London Deputy submits that charge sheet in the matter. Investigations have been completed. And charge sheet in the matter has been filed. On
On 16/5/2000, height charge sheet number 41
16/5/2023. ID charge sheet number
41.
41 of 2023. Stop. In that view of the matter, this court is of the view that the anticipatory bail petition can be closed, permitting the petitioners to approach the competent board before which the charge sheet as referred above has been filed. Full stop. Upon filing upon filing any such applications seeking bail, the competent court will hear the petitioners and pass necessary orders on its own merit, taking into account the law laid down by the apex court in Siddharth versus so and so and others. Upon due consideration of the individual merit, as well as taking into consideration the law laid down by the apex court, the competent court will thereafter pass necessary orders. Stop with the above observation. The anticipatory bail petition stands closed. Which court has it been filed? Borpeta. Borpeta. Okay.
While passing an order, the learned court will shall consider paragraph 6 of my petition. I have stated the whole story of it. Actually,
You-
the fact of learning is in your-
No, we said on individual merit.
My.
So you
You will file before the court below matter. Lordship may kindly see, only for reference, Lordship may kindly see page 26 and 27. The two persons who died, how they came prepared to attack these people, Lordship.
no, that is a matter of trial. It is reiterating, no, it is needless to say that the petitioners will be at liberty to urge all facts and make any submission pertaining to the case, which may have been made before this court while filing the application for bail before the competent board, before which the charge sheet has been filed.
Right.
With the above observation, the anticipatory bail petition stands closed.
Okay. Dispose of sticker. No.
Disposed of.
Item number 5.
Yes.
The joint has decided council officer in the year 1982, and therefore was promoted to the post called Subdivisional Fishery Development Department in the year 1992 and joined at Colorado.
Through which post is he asking from any sort of promotion?
That is district fishery development.
He retired as what? In which
He
post?
retired as subdivisional district fishery. Subdivisional. He was entrusted and he worked as district fishery development officer. Higher order that is 14/7/2005, and he joined as inside district fishery development officer on 27/2005. And it's my another one is the order.
What is the reason for not giving him promotion?
Reason, my lord, we have already filed one expedition during his service period. And this nothing goes to directed to dispose of that matter before the parent. And they have disposed just before one day. And there was yes.
Where is that application?
Next are electoral at this argument. This argument, they have shown some down smell. But this is already in fact of this because they have subsequently promoted my similarly to person. To the post.
I want to just make one thing else. The petitioner has already retired in 2014 to 13. He is claiming his promotion prospective from 2005. We are in 2013. Now, will this court ballot give an effect to a promotion to a person who has already retired in 2013?
If he was entitled to be promoted at that relevant point in time, but his promotion was wrongfully not considered, we may order giving him notional benefits. That is what he wants. Notional benefits. Financial benefits. Provided we find that his claim was correct.
My lord, fix the matter. Day after tomorrow, I will get the judgment, my lord. Where the Supreme Court's my lord was recently when we have dealt with few cases, such cases, my lord, where this coordinate bench did not interfere in such matters, my lord.
No, correct.
I will come with few judgments, my lord.
No, you certainly come, but we want to know the facts. At least tell us the
Fine,
facts,
fine,
why he
fine.
was not,
Fine.
promoted. Yes, please carry on.
Yes, my kindly see another page 57.
No, you were referring to page 39.
No, 39, that is. Yes, 39. I'm reading that there are two grounds they have mentioned that. And if we measure ground 1, there is no service route for the fishery services at present, and as the services matter of fishery officer is governed by the Assam Fisheries Council, the Equipment and Promotion Order 1989. As per provision laid down thereon, the Sub-Divisional Fishery Development Officer is a promotional post from Fisheries Extension Officer and allied cadre with 3 years services experience in the department and having minimum qualification PhD with postgraduate training in fishery science in CIFRI, CIFU, or any other equivalent training recognized by the ICAR or PFBR. Thanks. The petitioner was promoted to the post of Fishery Development Officer in the year 1992 from the post of Fishery Development Officer. By notification number 22, under regulation 4D of the HSC Limitation Conference Regulation 1951. Therefore, until and unless such promotion is regularized with the recommendation of the FSC, there exists no scope for consideration of further promotion of such promotee to the next higher court. In the instant case, recommendation of the FSC for regulation of the promotion of the petitioner following from others has been received in January 2009, and accordingly, their promotion in the post of Sub-Divisional Fishery Development Officer has been regularized in May 2013 and notification number 12. That is 16/5/2013. Then second government. As per service orders mentioned under 1 above, the district fishery development officer is a promotional post from the post of Sub-Divisional Fishery Development Officer, and its cadre strength as per the state service order is only 80. But consequent upon upgradation of the post of district fishery development officer, the district Dhuri, Uttaragarh, Sunitpur, Lakhimpur, Kamrup, Nagaon, Surhat, Dibrugarh, Karbi Anglon, Kasar, and Karimganj to higher scale of pay, rupees 1835 to 4,825 by an order issued under notification number 12 for Gazette 19/7/1993. It comes down to 12 and remaining 6 members of post of district fishery development officer in the district of Lalpura, Korsam, Malpai, Matapakil, Matagar, and Lagar are re-designated as additional district fishery development office in the existing pay scale by an order issued under notification number 19/7/1993. As a result of such bifurcation of the cadre of PSDO, it becomes anomalous for consideration of the promotion of SD, FD, or F, whether their promotion would be made to the upgraded post of district fishery development officer or to the post of additional DFQ, a non-existent post in the service order mentioned above. On the other hand, it becomes difficult to allow the Sub-Divisional Fishery Development Officer to the post of DFQ bypassing the intermediary post of additional district fishery development officer. Then round number 2. In ROP 2010, the pay scale of the post of DFQ, additional DFQ, and DFQ are shown as below. District Fishery Development Officer 12,000 to 60,000. Then additional district fishery development officer 8,000 to 35,000. Then the Sub-Divisional Fishery Development Officer 12,000 to 40,000. It is seen that pay scale of lower post, the lower post is higher than the pay scale of the higher post. So there exists difficulty for promotion from the post of Sub-Divisional Fishery Development Officer to the post of additional district fishery development officer due to pay anomaly. However, this anomaly has come to the notice of the government, and to deal with this situation, necessary steps for amalgamation of the post of additional district fishery development with the post of district fishery development officer in consultation with concerned departments have been taken up. And the petitioner, Sir Rafiqul Rahman, figures in share number 16 of the gradation list 2002 of the subdivision at fishery development office. In promotion to the named fire post, shall depend upon the suitability criteria to give the state in the of the project, as in when the matter is complete.
When were your similarly situated persons promoted?
Then manner and last question,
When?
page 57.
57.
This is without prejudice to their interseniority and subject to reversal without notice and without assigning any reason thereof, the following subdivisional fishery development officers are promoted to officiate.
Where is the gradation list? Gradation list, where is your seniority position?
Gradation is not, these are all subdivisional fishery development officers.
Are they senior or junior to you?
After retirement, those who were working together with the petitioner, they were all.
The promotion has to be made on what basis?
Yes.
What are the service orders? There is no service rule, apparently.
Actually, they have no service rule, they have not made on service order,
Hmm.
they made. And seniority,
Yes, Mr. Gaur. Please turn to page 57. 57. Last lecture.
I am also having this second copy of this.
Second copy also, I think continuous pagination is not there. In the affidavit,
It is matter, this.
affidavit in reply, Additional evidence.
Yes, ma'am, yes, yes,
additional affidavit.
yes, ma'am.
You come to the annexure 13.
And actually 30 minutes.
So,
That is 2015, after he has retired.
correct. So his case is that these persons were promoted.
Yes.
Now, if it is possible, if it is a case that he was asking for, now if you come back to the affidavit in opposition, which is filed. So come to page 4 of that affidavit in opposition, or 45 running page.
My.
Para number 16 it begins, you can come to the next page.
The figure of 7, para 23, 24 of the reputation.
So there was some pay anomaly. So there was some pay anomaly. There was they are subdivisional fishery development officer. They are claiming promotion to district fishery development officer. In between, there was some assistant district fishery officer. That post was a higher post, but it was carrying a lower salary. So therefore, there was a decision to amalgamate this post with subdivisional fishery officer.
Yes, ma'am.
In meanwhile, there is a set of service rules which are being in the draft stage and sent for approval, not finalized. Now, is it a case that nobody has been promoted, which obviously is belied by the order at the last page, annexure 13. Annexure 13 shows that there are some persons who are promoted. In 2015.
Master, my lord, first we need to find his seniority.
That is why we are pointing it out. It is not available here. So you have to find out what is his gradation, what is his position in the gradation list. Who are the officers who were promoted, who were placed below him and were promoted? And what is the criteria adopted for promotion in the absence of the service rules? Even the draft service rules can be relied upon. if the authority can take a conscious decision. Mr. Fukon, these people who are promoted at NHR 13, they are promoted after your retirement.
After my,
During your retirement, prior to your retirement, was anybody else promoted?
no, I do not know, but
So if you do not know, you have to find out. Your claim will come only when people below you have been promoted, you have been left out.
no.
During his service period.
Then what benefits can the court give you?
No, my lord, before retirement, I worked as district development officer. Was a guest.
In charge.
In charge.
Then you were reverted back.
No, my lord, not able to take that. I retired as in the last time, my lord, they have transferred me to one post where already I do. That is beside training development, training officer.
Let him show a single document, that we have promoted him. Only in charge is a different thing. We can give somebody in charge, we can revert back. In charge is never a pilot, a permanent post.
In charge for a long period, my lord.
My lord, but
But
they
in
are-
charge is in charge.
In
In
charge.
charge is in charge. You'll have to be regularly absorbed into that post. Mainly because you have worked for a long period of time, it may give you a claim for being considered. But you cannot say you are regularized.
I work.
You worked as an in charge.
Acting is acting, my lord. Somebody is, the capacity is not full.
Where is that earlier order of the court?
My lord, I would give both, my lord. It-
The direction was to, my lord, consider and pass an appropriate order. That is, page 30 is the fallout of this. Honorable Court.
Please come to page 40.
Yes, fine.
Come to the last paragraph, paragraph 4. His promotion to the next higher post will depend on the suitability criteria, procedure prescribed under the service orders. Where does one find the service orders? What is the criteria?
Service order given when promoting is completed.
Where does one find the service order?
My lord, here is the key, if I go by the tradition list file. Or in this tradition affidavit.
So then kindly come to page 41. The final order. The court does not, the authority does not dismiss his claim. It says that because of difficulties as mentioned above, it is taking time. They are not saying he is not entitled. So his entitlement is with regard to the suitable criteria prescribed. Where does one get the criteria? Mr. Fukon, is there any criteria prescribed, any service orders you have?
It is a functional post only.
Promotion, they will become very.
On what basis are you saying that? It is there in your department, you get it,
I will get it.
get it by Thursday. By Thursday,
I will fix this matter next, because these are old matters, correct? So it will take,
the whole matters, therefore,
I will fix the matter next week, Monday, madam. Because my lord giving me a lot of homework for this TC already, madam.
8th. He'll fix it on 8th, Tuesday. Hard learned counsel is fully parties. During the course of the hearing, upon the perusal of the order dated 30 December 2013 passed by the secretary to the government of Assam Fishery Department, disposing of the representation of the petitioner as directed by the court by the order dated 4/10/2013, passed in 5/663/2013. It appears that the promotion to the post of District Fishery Development Officer, to which post the petitioner is claiming promotion to, is to be effected on the basis of the suitability criteria procedure prescribed under the service orders . Namely, the Assam Fishery Services Recruitment Promotion Orders 1989. Can you repeat? Just service order part. His promotion to the same post will depend on the suitability criteria procedure prescribed under the so and so service order. Stop. In that view of the matter, it is necessary for the court to go to peruse the procedure prescribed under the said service order of 1989. Stop. A perusal of the pleadings does not reveal that the said service order is available in the paper book. Stop. And Government Council, Mr. or he is permitted a short date, permitted some time to procure the same and place it before the court on the next date fixed, along with the gradation list for the relevant period of time, where name of the petitioner might have figured. Stop. Let the matter be listed again on 8th of August. Enabling Mr. Dhar to procure and call for the relevant documents as directed. Copy of this order be furnished in the office of Mr. Dhar. List on 8th.
I heard one thing is, the promotion came into effect in 2015, whereas he was already out from the race.
We want to see what is the procedure prescribed. If he satisfies the procedure prescribed, you did not take his account, he is entitled to be at least considered.
I heard promotion is
There was, we didn't promote anybody by.
We don't know, where do you say that? You don't know, your order itself says that he has a claim. But because of anomalies, it is taking time. They are not saying that he's not entitled. In the order of the secretary. Final penultimate part.
Right.
So let us see what happens.
One correction is there, the time and I only.
You mention it in the next step, we'll correct.
Item number 6. Yes.
Let's do my lord, you know what the point that. As the city, it's in the Sima Saraksha ball mine. Sima Saraksha ball mine, they kind of understandable mine. Thereafter, my lord, he was having some matrimonial dispute, my lord. He remained sometimes for absent, my lord, because his wife filed so many cases against him, my lord. Thereafter, my lord, he was absent, my lord. 28 days punishment was given for causing bill, my lord. Here in the back and extra duty for 28. Thereafter, my lord, purpose notice was issued that your lordship will see at page 15.
Yes.
Thereafter, my lord, he was issued purpose notice. And there also they have come to the my lord, point number 4, my lord, awarded 28 days line confinement. He was there, my operative part. I'm reading at serial number 4. Absconded from the duty of 2009 without information to his superior, and he was dealt with so and so and awarded 28 days line confinement. There is the other allegation also, my lord. The serial number 8 is my lord, the commendation of the action will be regularized with granting in 74 days EOI and asks to that summarily trial on 3/4/2000 and awarded punishment under the Act 2007 and Rule 2009, Section 56, one of the extra guard duty for the offense and without leave up to superior or without any cause and absent from 2010. Then against academic body also undergoing at pre-inclusion training in the delegate from the training. Thereafter, my lord, page 17 is the so-called, my lord, the predetermined, my lord, keeping in the view of the above this post of record funds of Vikramjit Singh is not fit to remain in post, proposed to impose the penalty from dismissal of service. Now, so is hereby given opportunity to make the decision to impose penalty, so and made wish to make on the proposal penalty will be considered by the undersigned. Such representation, if any, should be made in writing and subordinate to reach from the undersigned, so than 15 days. There is, my lord, no other such departmental proceeding. And my lord, lordship will see page 15 is the Indian order, my lord. Immediately after show cause, my lord, whereas page 18, my lord, annex of 2. Whereas Vikramjit Singh is the convicted under Rule 26 of Sima Saraksha Bond, whereas it is considered that the conduct of Vikramjit Singh is the Ranga has been led to the conviction of to render the further retention of the government service reasonable. Such the warrant the execution of lesser penalty. And whereas the Vikramjit Singh Ranga was given opportunity to the personal hearing of the written explanation, now in the exercise of power under Rule 26 of Sima Saraksha Bond Rule 2009, there is section 10 of Sima Saraksha Bond undersigned thereby the discharge the same number of friends of Ranga from the effect from he was discharged. Firstly, madam, you have been chauffeurs that you remain absent and you have been given awarded 74 days was considered and 28 days was given punishment. Thereafter, my lord, we preferred an appeal before the competent authority, my lord. The competent authority by page 19, my lord, by page 19. With reference to the appeal dated 18/3/18 regarding the discharge from the service without giving showcase notice by Commandant Leland and requested to seriously things are going for the history of your case and records. Disciplinary proceeding, revealed that the showcase notice was absolutely by the 33 Commandant so dated 27/12, and you were also submitted the representation on 9/1/2011 against the shopper. Thus, your conviction or had taken discharge from the service by the commandant body without giving shopper's notice is baseless and misconduct. Further, as per Rule 29 of Civil Structure for an appeal has to be referred to the appellate authority within 90 days from the date of issue of the order. Since the termination order was issued on by the commandant, the time part one and cannot be exceeded to this related stage of the debate of the matter. Here, my lord, the merit referred an appeal, my lord, appeal was also dismissed, my lord, holding that, my lord, limitation here. Now, my lord, possible see from the usual dismissal order at page 18, it seems that, my lord, petitioner was subjected to two punishments. One is for the bill back of 28 days, another manner dismissal for this manner, that is too harsh manner. And why, my lord, it has taken place, my lord, petitioner was has been facing, my lord, criminal cases, my lord, from his wife's side. Ultimately, he offered divorce warrant was also issued, my lord, possibility and exercise, my lord, there is a case.
No, what are your grounds for challenging this?
My lord,
What are your grounds? Why are you challenging this order?
my lord, my ground is that, my lord, in the technicality, my lord, my appeal was dismissed, my lord. And firstly, my lord, the in order of dismissal, my lord, it was not been taken into as per the procedure laid down, my lord, how the republican procedure are to be initiated, my lord. No,
So essentially, you are saying that it's a case of double jeopardy. That
firstly, I was a case of a double jeopardy, and my lord, dismissal also, my lord, it is taken into account. It has not followed the established procedure, my lord. No chances of the cross examination, defense, my lord, statement, nothing, my lord, straight away shopper, then dismiss, my lord, nothing other ways, my lord. I have not been given chance to reduce my evidence, my lord, in support of the case, my lord. Then merely should be shoppers, then, my lord, I replied it.
what do the rules say?
Rule says, my lord, otherwise service jurisprudence, my lord, says
No, rules.
rules.
126 talks about SSP rules.
SSB rules.
My book was here, if you know, I think probably somebody else.
You should give a list of books or so that.
I had a book, my lord.
No, even for the court. Rules, SSB rules.
That was that I was imposed to a box of fire. And- I mean, very excited. Rule 26, it says about the punishment, how to be taken over. But what is the procedure, man? Merely issuance of show cause, reply then dismiss. That is not the way. On last occasion, it was directed also, my lord, to produce the relevant documents. From the authority, my lord.
The rule 26 say that the commanding officer is satisfied that the enrolled person is unsuitable. How is the satisfaction to be arrived at?
Let's take it as logic. It is not been on the offense. I have in my affidavit logic.
Not affidavit, rule 26.
It's the description logic, how the person is not
What is the procedure?
Name lordship. So lordship in my activity, I have given the details of this first on the lordship. How much time we have absent lordship?
No, we want to see, it is the commanding officer who is to arrive at the satisfaction.
Lordship.
Where is that satisfaction arrived at? In the records, in
This
the
order does not say.
rules? Where is that?
Order itself is that not. Or regarding unsuitability for service in resident in so and so lordship. So unsatisfactory due to the reasons submitted as under. So these are the reasons lordship.
Page number?
Page number 15, so called notice lordship.
This is the notice,
This is the notice for,
so called.
This is the so called notice lordship
Right.
we given him to reply lordship. He had submitted his reply lordship. A representation we served it to him on 27/12/2010. 9/1/2011 he submitted his representation. Then lordship, there is one provision that if he wants any financial benefit, he can submit his resignation as per Rule 26(2), but he refused to do that lordship. And on the basis of this lordship, we are not satisfied with his representation, and so dismissal order was there. There was a provision of appeal, but he had come after 2 years lordship. 90 days period was there for appeal lordship.
where is that order? Page number 16, is the court of inquiry order.
The appeal order has to be reflected. My lord. So these are the reasons for which it is satisfied.
Lordship. Still the record of 100 feet in order.
Proposal was issued on 27/12. And prior to that, my lord. Lordship will see page 50. Proposal was issued to me on 27/11. Prior to that, my lord, comfort sets come in advance.
Sorry?
How come, my lord, the action has taken place prior to the issuance of so notice? I was wrong, they have been taken.
Where is the court of, where is the COI procedure? This is for detailing the officers to conduct a court of inquiry. Where is the court of inquiry findings?
I understood from the student supply union. None of the documents and whatsoever my lord have so far. Was never of me, man. And what procedure they have followed, that is also.
You have admitted that you went on leave, you did not apply,
His unauthorized.
your
leave-
statements are recorded here.
Maybe, my lord, I have already been given punishment, my. And from the Shokos itself, this, my lord, 74 days they have condoned. I have given a punishment of 28 days, now. With that. And they have filed an affidavit opposition in two different, my lord. Same subject matter contradictory each other. My salary was returned. Someone said it is not entitled.
Subsequently, his salary was paid off.
It has gone returned back to the authority from the document available from that. But even otherwise also, my lord, I was deprived of principle of natural justice.
What natural justice? You have given your statements. You have been given your opportunity.
My lord, I had undergone the punishment, man. For the wrong I have committed, I have already faced 28 days bill back, man.
On 9 occasions, lordship, in some of his absent, we had granted him your lordship in many occasions. We had given him ample opportunity, lordship. And finally, this order was passed. And lastly, lordship, he had left his all belonging in the train lordship. Another person found it. And then he deposited it in the office lordship.
What belongings?
Lordship, his found his belonging unattended in the train lordship.
Arms.
Yes, lordship.
Arms.
Not only arms, his kit bag, etc. His
His kit bag is
My
his belonging.
lord, check, my lord. Police are running after me to arrest, my lord, because of
These are not, are they property?
it is not the government property. My own belonging.
And thereafter, he never, returned back after 80 days of.
74 days they have controlled, my lord. Why I have been subjected to 28 days?
I have given the list, lordship, how many times this petitioner was unauthorizedly absent, lordship. This is not only one occasion, lordship, and after considering all these aspects, all unauthorized absence period, he was, this order of dismissal was passed, lordship. Is it clear for
The terminate, dismissal from service was arrived at by the authority on what basis?
lordship, considering all lordship, this
No,
order.
all means what?
Order lordship.
Page
Page
number,
16 lordship. Here the details are given in page 15 and 16, then page 16. Clause 40, in view of abominable activities, so and so is not as suitable in retaining public service. In view of the above indiscipline activities, so and so is not suitable to retain in a post which may damage the image of the organization. Keeping in view of the above and his past service record of the said so and so is not fit to retain in the post and proposes to impose on him the penalty of dismissal from service.
no, under what provision are you doing it?
Lordship 26, lordship,
26. Rule or section?
rule lordship, rule 26. Termination of service of enrolled person on the ground of unsuitability.
So where is that finding of the commanding officer? Satisfaction of the commanding officer, where is it? You read 26, not below the so and so is satisfied. How is the satisfaction to be arrived at? If you read the order, there are instances of indiscipline recorded. Where have these instances are available in the record?
Instances are
See, if you look into say serial number 10,
lordship.
it says due to frequent indiscipline, you are sent back to so and so. What indiscipline?
Due to previous suspicious commission, sent back to battalion headquarters from so and so, and he had been given departure from so and so on for escort guard, and he was upon him during journey from Walden to Kathmandu in his boarding in the train. It is surprised that the train is absconded from the train, leaving behind his key item.
I'm referring to number 10, then you come to 13. You was given ample opportunity. By what, in what manner?
Lordship, because ample opportunity, lordship, on the, we had this, we have done all the, before the punishment, lordship. So, many opportunities we
No,
have
what
given.
we want to satisfy, what the court wants to find out, under the rules, commandant is to be satisfied. Now he has recorded his satisfaction. On what basis? Is it on the court of inquiry report? Is it on some inquiry made? Is it evident from his service record? On what basis?
How many service record, lordship?
So you show us that these are available in the records. That 1, 2, 3, 4, all these are evident from the record itself. These findings which the commandant has recorded must be available somewhere in the records. Because your court of inquiry does not recommend removal from service. The court of inquiry disciplinary action under section 21G. 21G, section 21G. He may be liable to suffer for a term which may term for imprisonment extending to 3 years. Now, whether this court of inquiry finding was overruled or subsequently there was another court of inquiry. It's a court of inquiry order. Court of inquiry is coming to a finding. Now that finding is not reflected here. That this court of inquiry had come to a finding. We disagree with the finding. We want to impose higher punishment. You go through the records. Go through the records, it's available. Usami record for that. See the records properly. You are getting the records and putting it before the court. You go through your records, tell us. But Mr. Borguian, prima facie as of now, assuming this court comes to a finding that the punishment was harsh, then as per the court of inquiry, you have to undergo imprisonment. You'll undergo imprisonment.
We are only, my lord, I still believe, my lord, as per the section. Even though, my lord, liberal view, my lord, I'm young boy, my lord, I think my wife, my parents, all are put behind the bar, my- because of my wife, my lord, I cannot continue. This apartment is liberal in life. Over and above, my lord, established procedure was what?
prima facie defense.
Yes, madam.
And 26 cannot come into play in the meeting. Some other thing will come.
But there was, prima facie, there is an act of indiscipline.
My lord, maybe my lord, because of my wife, my lord, lost so many cases.
No, no, no.
So from Jammu to even my working place police comes. Ultimately, my lord, I have to surrender, I have to give her all the costs. I have annexed some documents. Warrant, search
This
warrant.
order is another is not.
Actually, human being.
Yeah, another is not. More particularly, the case of district was not.
That is what we are saying. The satisfaction arrived by the commandant must be supported by some record. You have to correlate the record and point out insofar as page 15 is
Dismissal
concerned.
cannot come. There is no- but other punishment penalty cannot. My issue is that, my lord, I remain absent for some days.
What is the procedure prescribed under what rules?
Under for my lord, general principle of law is that, my lord, so it is not exercised in this particular act, my lord. So for departmental proceeding, issuance of.
Is there a set of different rules for service rules for departmental proceeding?
And there has to be, my lord, inquiry, then submission of defense, cross examination, all these part has to be there. I have to, if inquiry has been conducted, I should be participated and I should be given a copy. All these things are not there. Over and above, my lord, in single word, worship, it can be said, my lord, principle of natural justice was not followed. Which record to be followed in each and every case.
Madam, please come prepared. Come prepared. No, don't give us the dates. You tell us the procedure. What is the procedure? We will take it up on Thursday. Come prepared. Come prepared. You are showing us the rule, but you are not supporting it as to how the officer arrived at the finding. Unless you want to say, unless you want to say that the rule itself does not require
Opinion and recommendation is that one.
of whom?
Opinion and recommendation of the court does. Court of inquiry.
Court of inquiry.
Yes, opinion, may I read?
Court of inquiry.
Yes, sir.
That is for under 21G.
Yes, 21, under section 21A of SSB Act 2007.
21A or 21G.
But after going through the finding, the court is of the opinion that so and so willfully absented from leave under section 21A of SSB Act 2007 without sufficient cause overstayed leave granted to him under section 21B of SSB Act 2007. When in camp or elsewhere is found beyond any limit fixed or in any place without pass or written leave from his superior officer under section 21 Act of SSB Act without leave from his superior officer or without due course absented himself from training institution under section 21B of SSB Act 2007. The court therefore recommends that suitable disciplinary action may be taken against the individual under 21A, 21B, 21F and 21G of SSB Act 2007. So after
So 21G, you come to 21G.
without leave from his superior officer or without due cause, absent himself from any school or training institution when duly ordered to attend there. Sale on conviction by a force court be liable to suffer imprisonment for a term which may.
Conviction of a force court. Conviction of a force court.
Force court.
Where is the force court conviction?
instead of 3 years or such less punishment as in this act mentioned.
So the maximum punishment is 3 years, not dismissal. The court of inquiry opinion is, recommendation is 21G. 21G says maximum 3 years, that too on a force conviction, for a conviction of a force court. So whether these have been followed or not from the records,
What if it's on,
which is what we are trying to do. When can you come back? When can you come back? 8th.
Can we say it's a part hard matter, also when it's part hard matter?
Yeah, of course, it will be part heard, that you need not worry, because we have spent some amount of time. All right, 8th, at the request of heard learned counsels for the parties. At the request of MS.V. Devi, learned CGC, matter stands adjourned till 8th. As she, to enable her to go through the relevant reports and address the court. The hearing matter will be heard again on 8th as the hearing remains inconclusive.
Item number 7.
It is motion from grade 4 to grade 5. And the basic case of the petitioner was that not he was not only treated by adverse remarks in the APR of 2010, 11 and 11 plus subject. Not earlier on the earlier occasion, he approached this court by filing the petition number 356 of 2012. And at that point of time, logic as to what marks were given to him were not clear in the APRs. Logic, this court, you will find an order at page 120. The relevant portion is there. Paragraph 24.
There was a direction to hold a review DPC
Yes.
earlier.
Yes.
What happened to that?
Not that they say they communicated in logic to me, but then what happened is the logic that's not before your logic. It's at page 152 logic.
So why are you here before in this matter? What is your grievance?
Logic at page 153 logic will find it. Just prior to the lights, last paragraph.
150?
153 logics. Accordingly, the appropriate authority has duly considered the increase in your APR in ordinance from 2006 to 2014. Pertaining to your performance as an officer of the bank in different capacities, March obtained details different dates under 88 Your achievements under various dates mentioned in APR, your independent assessment of your performance during the period, observing special comments of your reporting plus reviewing authorities details in APRs have 11% and after examining all relevant facts related to reporting also more performance prepared year during the year 2008-2011 failure objectively with an open mind and dispose of the recommendation dated 10-10-2014 by observing and as follows. The observation of I have seen past performance when performance of in the branch. Maybe in training college we have done good, but as branch his performance was not so good and marks noted are fair and without any individualized or bad. Once you see the direction once and the consideration made lordship.
Hmm?
The direction was to consider the APS,
Where are the directions?
it's a page 151 lordship.
Yes.
Page 20, paragraph 25, that being the position and having regard to the law laid down by the ethics code, the following directions are hereby issued. Increase in the APR of the petitioner for both the years 2010 and 11 and 11 just be communicated to the petitioner within a period of 30 days from the date of receipt of the settlement copy of the order. Number two, the petitioner may submit representation before the bank against such increase within 30 days from the date of receipt of communication of the APR. Number three, such representation of the petitioner shall be considered by an authority of the bank which they hire is done the accepting authority. Consideration of the representation shall be done fairly and objectively with an open mind by the higher authority within a period of 2 months from the date of receipt of the representation. Instant taken on the representation shall be communicated to the petitioner. Once the above exercise is completed within this period specified and if the petitioner is eligible, bank for all the review is to consider case.
Let us come again. Firstly, the APR for 2010-11, 11-12 to be communicated. That was done. Then you submit a representation. That was also done. Then the representation to be considered by an authority and objectively decision to be taken on the representation. So what decision was taken?
Regard to the APS for the years 2010 and 11 only, because that was being taken into consideration while by the DPC while consideration of the promotion process. And
No, what decision was taken on the, in terms of the representation filed under 25.3? Page 121. Was any representation filed?
yes,
So what decision was taken?
the year it is plus 152 lodges.
152.
It starts at 152 and page 153 is the reason, the last line.
152. Yes.
The paragraph I just read out.
Yes.
Immediate paragraph.
Duly informed, you submitted detailed representation, placed before executive director.
And
Now, after that, was there a review DPC held?
no, it was not.
Why review DPC was not held?
That is conditional. Your worship can see
Right.
at page 153. You first will your worship may see
121.
the Honorable High Court's order, last order.
Hmm.
Your worship may kindly turn to page 121.
Hmm.
I'll read page 25 onwards.
Hmm.
That being the position and having regard to the law laid down by the apex court, the following directions are hereby issued. Entries in the APA of the petition for both the years 2010-11 and 2011-12 be communicated to the petitioner within a period of 30 days from the date of receipt of a certified copy of this order. The petitioner may submit representation before the bank against such entries within 30 days from the date of receipt of communication
the entries in the two APRs by him. Such representation of the petitioner shall be considered by an authority of the bank who is placed higher in office than the accepting authority. Consideration of the representation shall be done fairly and objectively with an open mind by the higher authority within a period of 2 months from the date of receipt of the representation. Decision taken on the representation shall be communicated to the petition. Now, this is important, my report. Once the above exercise is completed within the period specified and a petitioner attains eligibility. Now, this is the main line below. Petitioner attains eligibility, bank shall hold the review deficit to consider the case of the petitioner for promotion to senior management grade scale 5 along with the batch of respondent number so and so. Now, here he was not found eligible because he secured 59 marks. Whereas my lord, he ought to get 60 and above. Now, that is the reason he could not get through in the process of selection. The lordship will find the total marks at page 131.
So you mean to say that after his APR was communicated, the position in his APR was communicated for 2010, 11 and 11, 12.
Right.
He submitted representations. Those representations were considered, but he was still not found to be eligible
Right.
for a review DPC.
Exactly. So if he is found eligible, in that case, the question of review is others. No, no. State that is based 153 lawsuit. There is one day that lawsuit, they have considered the APRs of the year 2016, 2014. Whereas that was not required to be done lawsuit. It was only compared in 2011 and 2011. They rejected.
Where is that representation? 151. Sorry, where is that finding of the authority? 152.
It's at one. In 46 lawsuit, it starts at 146. And starts at 153.
You have to consider for only 2 years, Mr. Dr.
Only 2 years.
But you considered for 2006 to 14.
So the lawsuit may see the papers are here. They can take you.
No, page 153.
Melody lawsuit can come to page 131.
No, we are going by the findings in the representation. Page 153.
This honorable court directed us to show you the APRS result.
For 2 years.
Yes, 2010, 2011, 2011, 2012.
Because they were downgraded.
Yes. Now you also will find that
No,
at page 131 onwards.
we will not go into that. What we want to know is from the findings of the authority in the representation at page 153.
Yes.
The last paragraph, accordingly. The authority considered entries in the APR from so and so to so and so. That was not required to be done.
The consideration is 1 at 152, at page 152. Because you will find, we have to state that the honorable Mr. Justice Council issued the following direction. Paragraph 95, that being the position and having regard to the law laid down by the appeals court, the following directions are hereby issued. Entries in APR of the petitioner for both the years 2010-11, 2011-12 be communicated to the petition within period of 40 days. Then you should turn to page 152.
No, you read the second part, serial number 2.
Petitioner may submit representation before the bank against.
Against such entries.
Yes.
Such entries reflect to 2010, 11 and 11, 12.
Exactly.
So that having been done, you now consider the representation with effect from 2006. When his representation is with regard to 10, 11, 11, 12.
You know, the consideration, the papers before Lofi, I'm sure that 2 years paper will be given. As directed by this honorable court, 2010-11 and 2011-12. That's the reason I said, my lord, your lordship may.
No, you have given, but your order says 2006 to 14. That is what we are trying to understand. Page number 153.
Yes.
Appropriate authority considered your APRs from 2006 to 14. It is evident in the order itself.
Accordingly, in deference to above directions of Honorable Guwahati High Court, the bank has been informed you. Entries in the APR for both the years 2010-11.
No, not this paragraph, below that. The,
Accordingly, the appropriate authority has duly considered entries in your APR in original from 2006 to 2014 pertaining to your performance as an officer of the bank in different capacities. Marks obtained against different acts under so and so. Achievement under various acts mentioned in so and so, independent assessment of own performance during a period. Observation, special comments of your reporting so and so at 11 point of time, and after examining all relevant facts related to reporting of your work performance in the area during the year 2010-11 fairly and objectively with an open mind. Dispose of your representation dated so and so. Now they have referred all these things, but then the consideration was the report of 2010-11 and 2011-12. That is the record to the different lordships from page 131 onwards.
no, reference is all right, but your order refers to the,
Those are quite unnecessarily. The consideration was for those 2 years.
is there any appellate forum?
My lord, yes, so I believe for to say. Ultimately, they will go to CMD.
So have you filed any appeals?
Yes, this filed it directly.
No. Very basic question, my lord. The lordship will find, in order to get promotion from scale 4 to scale 5. You know, what he has to do, he will have to get
No, what is the procedure for promotion? What is the procedure for promotion?
from scale 4 to scale 5. You know, so far, last
We are not asking the eligibility. What is the procedure?
procedure, my lord, there will be interview. And in the interview, you will have to be eligible. That means in the last 3 years, every year you will have to achieve 60 marks. Then you will be called for interview, others not. So in this case, what happened?
He got 59.
Each year you will have to get, in the next year he got 95%, but that will not work. In the 2011, he got only 59, 1 mark less. So unfortunately. So therefore, because of that, he was not eligible. That is the case. Otherwise, 45 candidates, they got the promotion.
For all the other years, how much did he get?
In the next year, he got 95.
Prior to that,
Prior to that, those records I don't have. Because this one of the, because he is required to show in the last 2 years, 2010-11, 2011, for consideration of the.
what?
There is a policy being followed by the bank center. Actually, what had happened was he was working as an employee of the UPI bank. Subsequently, that the bank was merged with PNB. So now the institution is PNB. He basically got absorbed.
There was a direction by the court to give you the APR remarks for 2 years, which was not given to you earlier. That has been given. You filed a representation. They refused to pass an order enhancing. Now, you did not file an appeal against that rejection of the representation. No appeal. So therefore now your grievance is to give you a direction for promotion. Now that direction to promotion will have to be as per the procedure of law, you must fall within the eligibility criteria.
But Lordship, I have challenged this order, whereby they say that they have considered my representation Lordship. And there is Lordship, separate that Lordship, they have not considered it for only 2011 or 2011.
Let us assume that it was considered for only 2 years. Let us assume. Assuming, then also their ability, they have refused to accept.
How they have considered, that is also not before your Lordship. Only conveying the order of the higher authority Lordship, and nothing else. This later.
It is evident,
It's not your Lordship, the page my senior has referred to Lordship.
hmm,
Page 150. Once it starts at 127. Lordship. Those were being considered by the reviewing authority at in the year 2009, 2011 itself. The date for. Page 126, Lordship of Ireland. 125 is okay. All the dates are of 2011 only. Not subsequent the order passed by this mayor. So this was the one which was earlier considered.
on what basis is the percentage arrived at? 59%.
Page, it starts at page 127.
Yes.
These are the marks given to me. It's the quality of performance, there is 20 marks, and I was given 13 marks. And it is quality of judgment and decision, I was given 6 out of 10.
No, we can see that. We're asking you one question that the eligibility criteria is 60. You got 59. From where do you say that?
Lordship, NHR, Lordship, there is a guideline already formulated by the authorities, but then in the advertisement they say, what's the guidelines that you need to secure 60% marks in the APR for being called for the interview. And that's at page 56, Lordship.
No, from the papers which was the APR, these are the APRs, 126.
No,
What are these?
this is the selection process, how this should be.
No, 126, page number 126.
Lordship, yes.
These are the APR.
It's very communicated with the
Subsequently,
the directions of the honorable.
correct. Now here you tell us how much mark you got.
Lordship. Finally, it's a page 121. For the year 2010.
131. 131 is blank here. '59, 129. Compilation.
Compilation of the. Yes, the responsibility area. I got the people.
Now, according to you,
Such
in your representation, after going through this APAR, where has the department, where has the authorities gone wrong in downgrading you?
current paragraph 19 of my application.
Page number,
Page number 22.
page number
22. Lordship.
22.
Possible paragraph 18 also, Lordship. It's a page 21. regard to what I submitted, just it's being referred to as paragraph 18.
Yes.
I'm reading from the after the project, there it is the above position would reveal that the respondents will reserving the requirement for the immediately and arbitrary consider the performance prior to the year 2011. It is stated that in the year 2011, the petitioner never worked for a single day at branch head. Therefore, his performance as branch head cannot be the basis for any inferior grading for 2010-11 as decided above by the respondent. In the year 2010-11, the petitioner was working as chief manager of regional office Nagaon and his achievement was excellent. In this context, it's pertinent to mention here that the petitioner worked as branch head up to July 2009 and thereafter he was transferred to regional office, not the branch head assignment, and in December 2009, while being posted at regional office Nagaon, petitioner got promotion from middle management grade scale 3 to senior management grade scale 4, considering his performance pertaining to the period as branch head. It is designated after the promotion in 2009, his performance as branch head cannot be used to his advantage in getting his performance in the year 2010-11. However, the review order dated 2014 was issued primarily basing on the performance of the petitioner prior to the year 2010-11, which is again a clear example of non-application of mine. Hence, the on this score alone, the review order dated 11/12/2014 is liable to say decided part.
Here at page 22, you make a statement that in 2010-11, you're working as chief manager and your achievement was excellent. On what basis do you say that? Page number?
Yes, 155. Also, 155.
Yes.
These were the achievements noted when he was posted there in. Yes. Yes, sir.
How do we come to a finding that these are excellent achievements?
Paragraph 23 documents, I mean, at page 26.
Yes.
That the people state that the remarks satisfactory reported by the reporting authority on the study.
Yeah, we are not going into all this. What you're not understanding, we are not your reporting, reviewing and accepting authority. You are making a statement that in terms of the court's order, they have given you the APAR, you have filed an application, that representation was rejected. And
Kindly on page 27 months. In this, from the second line itself, the thing that was done in Nagaon branch project, that's being reflected clearly.
reflected on what basis?
The image of the bank was active.
Mr. Sarma, it is not your perception that matters. It must be reflected in an objective manner, supported by the records.
The numbers within the project. But you will see that page 159. How the amount that is recovered from.
These are your perception, these are your assessments.
You know, it's being downloaded from the website.
You have to give a comparison between your achievements made earlier from 2004, vis-a-vis the findings in 2010 and 11, and then draw a conclusion that when you had secured or the subsequent years where you got 95%, then for the same work, if you have got 60% or above, then why in 2010, 11 and 11, 12, you are not given the same marking for?
That is what not they say in their application. They say that they did not communicate the APR, because they consider that this marking which they have given to me, that accord.
It is for you to decide. What you have done, you know.
What are reason lordship? They did not communicate to us the APRs.
APRs are not, APRs have now been communicated subsequent to the orders of the.
11,
You mean to say that the APRs for the earlier years have also not been communicated? Yes, Mr. Doctor. How will you find out? How will the court decide?
Now, my lord, your lordship, can you see what order was passed by this one only court in earlier occasion? The first issue is to offer, my lord, the validity of the circular dated 10/5/2012. That has been foreclosed. My lord, it suffers from the constructive rest in as much as your lordship, can you see at page 117? What is the order given? Paragraph 18.
Yes.
Though learned counsel to the petitioner had argued both the issues, that is validity of the circular dated 10/5/2012, as well as non-communication of APR to the years under consideration to the petitioner. Court could discern more emphasis being laid on the second issue. Maybe because the legal position governing the second issue has been settled by the Honorable Supreme Court. As a matter of fact, learned counsel to the bank, in the course of this argument, I have to concede the legal position on the second issue based on the law and financial.
So what is the circular? What is the circular about?
The circular melody, your lordship, that's the main issue, your lordship, can you see at page. Lord, the page 55. Your
Yes.
lordship may turn to page 56. Eligibility criteria. The lordship may see selection process was four. Selection for promotion shall be made on the basis of the job performance and group discussion and personal interview. Only those candidates shall be called for group discussion and personal interview who have scored minimum 60% marks in APR for each of the years.
Mr. None of the councils are answering the query of the court. The query of the court is that earlier the petitioner had come with twofold arguments. Number one, this circular is bad, it has deviated, this, that was abandoned. Subsequently, the court came to a finding that in view of the law laid down, if you have downgraded somebody, you are duty bound to inform him, which was not done.
No, we have informed.
Subsequently,
For this, earlier occasion we did not.
exactly. So that was the direction of the court.
Right.
Now, the court did not stop at that. The court went further to say that once you downgrade, you give him the representations, he will file representations, you give a finding on them, on those, for those particular years.
Let me read once again. Petitioner may submit representation to the bank against such entry within 30 days. Such representation in petition which may be considered when authority of the bank is paid higher. Consideration of the representation is done fairly and objectively with an open mind by the higher authority within a period of 2 months from the date of receipt of the representation. Decision taken on the
You'll have to read para 2, 25.2. Submit representation against such entries.
Represented before the bank against such entries.
That such entries will have to be read in relation to 25.1, which is for the years 2010, 11 and 11, 12.
Therefore, whatever marks we have given, we have shown my lord
So
category.
you have shown,
Yes.
but now read the order subsequently. Number 4. Once you have given him the marks and he has submitted the representation, it has to be objectively evaluated by the competent authority.
Right.
Then the authority has to give an objective evaluation and come to a finding that whether he attains eligibility or not. If he attains eligibility, then a review DPC.
Therefore, the marks how we have given, my lord, we have categorically stated
Correct.
in which
But
subject.
how have you objectively evaluated those marks? You have merely stated that these are the marks we have given, this is the amount. Now, how do you objectively evaluate unless you compare with the earlier years where you scored more than 60%?
That is in the mind of the officer who has done it. Now, that cannot be spelled out.
Why not?
You know, what is in his mind?
No, not on there.
I don't.
The
think
matter
that's
is
not
before,
finding.
matter is before a court. This order was passed. Bank did not go in appeal or a review saying that it cannot be done.
No, we have not been agreed by that. You know,
If you're
whatever
not
marks-
aggrieved, then you're duty bound to comply with this order. You have to decide his eligibility.
No matter what I understand.
Ah.
The observation given by this honorable court is the, that whatever marks you have given, you were required to give under the law. That you must inform him whether he has done fairly or average, below average, whatever it is.
That is the first part.
So therefore, we have done that.
Right.
What marks he has got it. Now, what was any sort
No,
of
that is the
assessment?
part, there are 3 parts in the order, 4 parts. First, inform him the marks.
Yes.
Second, if he wants to file a representation, he files. Third, that representation is to be objectively decided. Fourth, if he is found eligible, then review DPC. Now, between the third and the fourth, you have complied with the first and the second. Third, you say you have done it objectively, officer has given a fair, unbiased mark. Now, how do you comply with the fourth? If he's attained eligibility, you say he's not eligible. He's not eligible. That was his ground which he of challenge in the earlier petition. That because he was not eligible, he was not aware, it was not communicated. Now it has been communicated. Liberty granted by the court.
And we have informed him.
You have informed him, but the liberty is granted to decide his eligibility. On what basis?
And we have shown how much marks in each subject.
No, Mr.
Well, I
Doctor,
understand-
Mr. Doctor.
I could understand.
Yes, I am aware that you have understood from the first word go. I have understood that.
But my lord, you have to kindly.
I have equally understood that the bank is represented by a very astute civil lawyer. We are aware of that.
No, what I say,
What what we are trying to understand is, the court said you decide on the eligibility.
yes,
You have already decided that he is secured 59 marks.
Right.
But you did not communicate with him
earlier occasion,
earlier occasion.
Yes.
Now the court says you communicate.
we have communicated.
You have done it. But the court again says decide eligibility. If he attains eligibility, what is the meaning of that? It means that on the representation, there has to be a qualitative objective finding. Whether he attains eligibility or not, you cannot say that he is disqualified. Otherwise, this direction number 4 carries no meaning.
Direction, 4 is coming, my lord, once he found to be eligible,
Correct.
then only the review question.
Court did not interfere with your,
Yes.
court did not overrule with the stand of the bank that he did not obtain 59%.
Very good.
Which means he was already not qualified. If that be so, what is the meaning that you can ascribe to this serial number 4? Some meaning has to be given, unless you go in appeal or a review, which you have not done.
Possibly what, the way I thought, possibly the bank officer also thought in that manner. They thought, my lord, what marks he has got, that we should inform him, and they have done. it.
That is the first part. Subsequently, a representation for what purpose? To see whether he is eligible, not eligible, that there has to be a qualitative decision on that.
Whether the reflection of the mind of the officer who has put the mark,
We don't know.
my lord.
We don't know. To my mind, he's doing the same nature of job for the last 3-4 years, before that and after that. So his APR for the earlier years, where he has scored more than 50%, 60%, and 95, as you say, will have to be put into comparison with these years to say that in these were his figures, therefore he got that mark. In this year, he did not achieve these figures, therefore he did not get it. Something like that.
Now, another thing you have to tell you, see, whether that particular officer who wrote this essay, whether he is in the.
We are only going by what the court had directed.
My lord,
This
why
court
the-
direction, not being complied, you know the consequences. Court had categorically directed 4. You cannot say that the court did not give a meaningful direction.
Well, that is true, my lord, but. the
So,
direction-
his grievance before the court in the first round was twofold. Number one, that circular, which is abundant. Number two, I was not communicated. Now, the fact that he was not promoted is the first reason why he came before the court. He was not promoted because according to the bank, he did not secure 60%, which means he was not eligible. So if that be the case and the court did not interfere with those findings, there has to be a meaningful, some meaning will have to be given as to the direction of the court to file a representation. And then if he is found eligible,
Lord, what at this stage, my lord, what is also can do. With the specific direction. For the reflection of the mind of the officer, we have to respect it. Otherwise, my lord,
we will direct the officer to be in court with all records and ask him to reevaluate. Here, what is the point in reflecting and sending it back? He'll give some order, again go in appeal, again come before this court after 3 years.
even my lord, in that case also, the position will not improve.
We don't know.
Here what
We don't know. We are not saying promote him. We are saying that this is an order of the court, comply. The obvious thing to do is to initiate contempt proceedings because these orders have not been complied with. And why the officer has deliberately not complied with it? There was a confusion, could have filed an application for clarification, if required. Officer has merely said, this is what the marks we have given, therefore he is not qualified. Obviously, that is evident because the court has accepted he was not qualified.
So, para 3,
Hmm.
such representation of the petitioner shall be considered by an authority of the bank. Is paid higher in office than the accepting authority. Consideration of the representation shall be done fairly and objectively. It is often made by the higher authority within a period of 2 months. In the date of receipt of the representation. So this part we have done.
You have done it. What about 4?
Once the above exercise is completed.
Within the period?
Specified and if petitioner attains eligibility. Now, we did not attain the
He did not attain because you relied on the earlier results.
No, obviously, my lord, we have to see 2010-11 and 11-12 for 2 years in terms of the circular.
No, Mr. You have argued, we have heard, but I don't think we can accept your interpretation of these orders.
This is what my understanding.
Okay. Yes, anything more?
Nothing, that part with regard to circular.
You have already abandoned.
Yes, that one thing, and
Ah.
I just wanted to say about the tax bucket. That lordship, annexure 1 was the guideline, lordship, that was the followed the February 2012, lordship. There was a specific way method in which the promotions will be conducted, but what are the lordship subsequently when this circular.
We are now concerned with the findings of the authority vis-a-vis the orders passed by this court.
Not.
Prima facie, we are of the view that the order has not been complied with.
That one more thing.
Hmm.
That lordship, the remarks which were given to you Lord, we find that page 127, in the earlier consideration logic of the when preparing my appeal, they have given against the quality of performance logic, they have given a very good logic. Capable of
You have not brought this out.
logic.
You have not brought pleaded, this is not your pleaded case.
But then what I am trying to say is not that this goes against me, this is an adverse remark against me, logic, but then logic, they have not substantiated the logic, why they have found these things to be against me. Logic.
Where have you pleaded that?
There, logic.
Paragraph. Anything more, Mr. Dr.?
I give it logic. It's there.
All right.
Lord, what my learned friend is saying, in the promotion rule, my lord, there is a clause that time to time it can be applied. So therefore, that argument will not be taken. Because he cannot argue that because there is abundance.
No, I am not arguing that, I was just clarifying the fact. Logic, I have very big aspect against which I was given marks, logic, with paragraph 19. I am just giving the paragraph where I have dealt with it. It is the quality of performance I have dealt with it in paragraph 19 of my readings of it. And if you page 127 of it, those marks and the remarks that they would have given logic.
All right.
Did not.
For orders on 8th. 8th. For orders.
Okay.
Art Learned Council. Take them to news.
May I give those paragraphs logic very nice?
You,
I'll give it to writing.
you give it in writing.
Item number 8.
Right, logic.
Yes.
Hello, here the petitioner was a constable member under the CRP.
Why this constable are so unruly? Why the indiscipline every matter?
My lord.
Huh?
My lord,
You are in discipline forces.
actually, he sustained some injury over his head due to an accident in 2009. And thereafter, my lord, the authority granted him leave, page 42.
Hmm.
Authority granted him leave, my lord, and during the leave period, my lord, he came to his native place, his parents brought him for treatment, my lord, at Norway. And thereafter, in fact, my lord, he was also admitted
Hmm.
before the Titchwood Mental Health Hospital, my lord.
Hmm.
And in the meantime, my lord, the commandant, my lord,
Yes.
issued memorandum. My lord, dated 18th of April 2011, page 30, election 9. Yeah, my lord, search is the page 31.
You filed some petition earlier.
Yes, my lord. Here, my lord, this repetition was, my lord, and this was, my lord, dismissed. On the ground saying that, my lord, I ordered that,
I have not understood. This was dismissed.
yes,
Then,
and then after I challenged before the honorable division that, my lord, the honorable division must set aside the dismissal order, remanded matter back for.
where is that order?
Yes. Resettlement of the 164 lotion, this is the order I am passing it. 27/4/2023. Repetition order as well as the retail order.
What was the finding?
There are nine, there are six, there are nine of the retail order. No? And also female, there is no lack of resolution willful absence. In the article of charges as well as the order imposing penalty. The pertinent grounds payload from the applicant, the repeats of that there is no allegation against the applicant repulsion of being willful absent from duty. In this regard, we would like to refer the appointment made in period of 17 of the case. It is certain of the days before the Lana changes which had been taken of at paragraph 13 of the Union. Considering the pending and paragraph 14 of the Union judgment, the Lana judge observed that the petitioner has not made any dismissal order on the ground of procedural irregularities.
Demand for refreshing. Yes, para 13-14 inconsistent.
Yes,
So what does it say?
there are 31, it says, my lord, that my absence itself says willful. So there, that should not be proved, such should not be there to the willfulness. That is contrary to this judgment, my lord, reported in the Kusan B. Parmar case 2012 SCC 178, my lord.
So para 13 said. There is no finding that he was willfully absent.
Yes. And the procedural irregularity.
Motion. Can I read that? However, the petitioners also submit that there is no finding by the inquiry officer that the petitioner was willfully absent. In words, of course, that he was not willfully absent, it's not there. The fact that the medical certificate says that the petitioner did not suffer from any psychiatric illness during the period of observation implies that the petitioner was never having any mental disorder.
or imbalance as such. The only implication that can arise from the above is that the petitioner was having normal mental capability and he had remained willfully absent without taking any permission from the respondent for 347 days. Now, this gentleman was absent for 347 days. He submits.
No, we are trying to understand para 13-14 in the context of the division bench.
Right.
Yes, no,
Right.
yes, division bench has. Now, what is there in 13? It is one side, his submission, the opening part of para 13.
13 says no finding on willful absence by the inquiry.
That is his submission. Those the petitioner's counsel has submitted. That is his submission. And what the court finds is.
Essentially, the division bench was saying that there is no finding, there is no evidence to support willful absence.
Right.
That is what, and in fact, that is not a word in the report that says it is willful. But let us go to the facts. Whether it is written or it is not written, what does the facts disclose? Now, his plea of remaining absent for 347 days was that he was mentally ill. Now, what does he do? If I may take your lordship to paragraph 9 of the same judgment. The single judge has dealt with it.
Para 9 of single judge. Yes.
I'm sorry, lordship. Para 11. Sorry.
Yes.
Whether he was willfully absent or whether he was not willfully absent. This is the only plea. If your lordship will look into the petition, this is the only plea that he has taken in the petition. With respect to the petitioner's case, that the petitioner was not intentionally absent from duty, but was due to his mental disorder. That is also reflected in paragraph 13. This court finds that while the petitioner has been charged with unauthorized absence from 14/10/2010 to 1/7/2011 and from 19/7/2011 to 12/10/2011, the petitioner has submitted medical documents which are subsequent to the dates mentioned above. These medical documents are subsequent. The certificate dated 26/11/2016 issued by the mental hospital states. This is to certify that Pankaj Virgul 28, so and so, I am not going to that, was admitted in this institute on 28/10/2011. Now you will see 28/10/2011, he was admitted for diagnosis and treatment. But he got discharged on his own request on 7/11/2011. However, on evaluation, no psychiatric illness was found during the period of his observation. Following discharge, he did not come for any follow-up till 26/3/2016.
So essentially, it is a case of
He has later on tried to make up a case by going to the OPD.
unauthorized absence.
Yes, Lordship. It is unauthorized absence.
No, we are not for losing your submission. We are just trying to understand division bench order vis-a-vis the single bench.
Under the honorable division bench of the pretext if the judgment has been interpreted, on the appreciation of the judgment passed by the honorable Supreme Court in Kusangi Burman. There, my lord. It was held that in case of unauthorized absence, an officer, a person may have unauthorized absence.
There is a request from the court. We are grateful and happy that you are giving us printouts. But we'll request you to give us the citation. We can take it out, take out the printouts, any matter that you have.
Next.
No apologies intended. What I'm saying is, why do you take the trouble to give us copies? We have our own system here. You just give us the citations, the rules, the books, whatever you require, give it to the court master. So well before the matter is started, because they will require some time to take it. And we'll have these copies. Otherwise, what happens is, you are giving these copies, if the matter doesn't end today, it may be here, it may be somewhere else. That is where the difficulty is. Yes,
First, let us.
For part.
2012 T SSC 170.
yes.
Here also, discipline for para 11.
Parmar, was it not,
Yes, this is
I think
the.
it was watered down.
That is, no, that part.
Huh?
That is the other part of this.
That relating to Manipur. The
No.
subsequently a case from Manipur had gone to the Supreme Court where that judgment was watered down. Parmar,
Not on this issue,
not on this issue, yes, but Parmar.
but what he is submitting, the 28th July judgment will partial to the tax. Here also para 11, this is also the discipline for, so the delay is unauthorized absence for a period of 234 days. Para 11, third line. Now, Lordship, here for consideration of the paragraph para 17, 18 and 19.
Yes,
May I read a small paragraph?
yes,
If the absence in the result of compelling circumstances under which it was not possible to report or perform duty, such absence cannot be held to be willful. Absence from duty without any application of prior permission may amount to unauthorized absence, but it does not always mean willful. There may be different eventualities due to which an employee may abstain from duty, including compelling circumstances beyond his control, like illness, accident, hospitalization, etc. But in such case, employee cannot be held guilty of failure of devotion to duty or behavior unbecoming of a common servant. In a departmental proceeding, if allegation of unauthorized absence from duty is made, the disciplinary authority is required to prove that the absence is willful. In the absence of such finding, the absence will not amount to misconduct. In present case, the inquiry officer on appreciation evidence, though he held that the appellant was unauthorizedly absent from duty, but failed to hold that the absence was willful. The disciplinary authority has also, the appellate authority failed to appreciate the same and the wrong held that the appellant guilty. Here is a case. It is a case of unauthorized absence. In unauthorized absence, the search must be that his unauthorized absence leading to his unauthorized absence which is willfully absent, and therefore is unbecoming of being a member of the force. Willful allegation must be there in the statement of allegation. In my humble judgment, as per this judgment, page 31 is the allegation, statement of allegation, article. Here, from the replication, page 31. Is issued by the commandant. This is attached along with the annexure 9, memorandum dated 18 April 2011. That is said showing so possible while functioning as CPCD General Duty, Mahavir Nagar campus, New Delhi, has committed an act of misconduct in his capacity as member for some 11-1 CRPF 1949 in the he deserted from colonial line. So at around 17 hours and still absconding without any information or prior permission on the consequence of his presence to put order and discipline of the force. My entire submission is that in absence of proving or the allegation that your absence is willful, so there has been procedural lapse. Number 2, so far the inquiry conducted, we were given the relevant portion of the inquiry. Inquiry kindly see page 35. This was forwarded. 36. And the relevant portion of the inquiry is a case 38. Analysis of evidence obtained. Proceed on, madam. Analysis of the evidence obtained, madam. This is important, madam. On analysis of evidence, found that there is no information as to why so-and-so campus has absconded from the campus line. Whereas on the basis of statement of Pankaj Kasturba, the learned that as he did not know anything as to what had happened to him due to his mental illness or the illness. I already stated in para 4 how he made an accident and annexure 2-3 they have given the leave for medical treatment. So there is a connection, my lord.
Where is that statement made?
Case 38, my lord.
No. Where have you made this statement?
Oh, yeah. Para 4, my lord.
No, before the authorities. This is a reflection of the statement made by the delinquent employee.
Delinquent employee, he said, my lord, I was suffering from some illness, my lord.
Is it in writing, given somewhere before the authorities? WS or something?
Whatever I submitted, my lord.
Okay.
This is from the inquiry report I am saying. So before the inquiry officer, he stated that due to some illness, he did not know what was his, what happened to him. So he could not, this is the reason he stated now before the. So now, my lord, finding of investigation is also important. Case 39.
No, this is why I wanted to see, is like if the person is suffering from mental stress and illness. The first part is all right. He did not know what had happened to him as he was suffering from so and so. Therefore, he absconded. Absconding is a willful conduct.
No, abscond means, my lord, before that, my lord, this.
Is this absconding an interpretation by the department? Or is it a statement made by the delinquent?
No, my lord, this is writing of the inquiry, sir. Page 20 and, my lord, page 21 is important to read. Has to be read along with this one. The leave period they granted. Along with this statement, my lord. Initially, here he was granted leave. Page 20, leave for 30 days, unleave. And he could not, my lord, recover thereafter again. My lord, this notice was given, my lord. Subject is important, my lord. Page 20. It is informed you that you were proceeded on 30 days unleave. Initially, he was on leave, unleave with effect from 6/1/2010 to 4/2/2010. With direction to report back joint duty on 4/2010. But he had failed to do and remain overstayed from leave with effect 5/2010. And therefore, initially he was granted leave. He was supposed to join on duty 4/2010. He did not. And the reason behind this, my lord, although initially some treatment was there, however, here in this case, my lord, he was also admitted before the, my lord, mental health.
Where are the medical documents, medical papers?
Matter. OPD slip we have given, my lord, the page 22 and page 27. This is the certificate. Lordship will kindly mark the date. No, he has already pointed out that this is
Page
after.
number 27.
Yes. 27. It's 26/11/2016.
And the date of occurrence? The incident happened.
In 2009. 2009 December. And the.
You were admitted in 11.
My lord. In between, my lord, as OPD treatment, there was OPD treatment going on, my lord, the matter. If there are unliterated person, my lord, in affidavit in reply, we have given the document that our mother intimated the authority that my son is suffering from so and so disease. So therefore kindly consider. That stage was again, my lord, already the punishment of the issue. My lord, these are the parents, my lord, illiterate person. However, my lord, how this,
Do you have any prescription given by this institute
not,
at the time, or medical advice at the time you were admitted?
actually, everything here, mismatch, and this was also issued for RTA, my lord. After he came, also he came later on late, my lord. And RTA application kindly say next statement. It is his document we have to obtain through RTA. my lord. He mismatched everything. my lord.
But this
Now
certificate, no, but this certificate, you read the certificate,
Yes.
doesn't support you.
That's correct, my lord. I am not on the certificate.
Uh,
I am now, my lord, before your lordship that my absence may be unauthorized absence, but my absence is not willful. I was suffering something,
That's what I'm saying, that suffering from something has to be supported by some evidence.
but yes, my lord.
The medical certificate on which you are relying on says that you were admitted in 2011,
And therefore, my lord, I pray, my
But-
lord, that the lordship may
but-
kindly,
but on evaluation, no psychiatric illness means in 2011 itself, there was no psychiatric illness. So if you are suffering from psychiatric illness in 2009, between 9 to 11, is there any document to say that? Otherwise, it will be treated as unauthorized.
These are the documents, my lord. And now the finding of investigation, my lord, case 39. Finding of investigation, my lord. Para 8, my lord. From the Department of Education, the land focus was expanded from 17 hour 5 p.m. force from the companies who have informed on basis witness number 3 and evidence number 1 on the basis of evidence 2, 3, 4. And FIR was low level from the state bureau on 15/10/2010. From 20/10/2010, a complaint was made to individual make it from the person from the state bureau and magnitude prayer. And the commandant 5 p.m. was issued a warrant to arrest in connection with so and so forth. The police failed to produce from the state bureau statement on the basis of evidence of types 6 and 7 witness 3. Initiated to stop the payment of salary allowance to the on the basis of evidence number 8, Constable Principal Pankaj Besbura appeared before investigating officer back on 19/7/2011. He again absconded. On the basis of witness number 120, this is an important number. Constable Pankaj Besbura was found to be obedient to his duty, but no information could be found as to why he absconded. As per the person accused, he absconded and remained absent owing to his mental state for illness. This reason before the
Where is the statement of witness 1, 2, and 3?
the record will be there. Therefore, my lord, my entire case is that, my lord, lack of following procedure. In a case of unauthorized absence, the willful act should be there, the allegation should be there in the statement of allegation. The inquiry officer has to come to a finding that this absence was willful. There is no finding. Kindly see, my lord. Now the page 13 on last page, my lord. On the basis of evidence numbers after Pankaj Besbura had been served notice, I was at appeared before the preliminary stage of invasion part on 19/7/2011. He again absconded before the completion of invasion. Now, suggestion from the statement of accused and other documents submitted on search level, Pankaj Besbura had accused appeared before IO after he had been served notice by IO, but he again absconded before completion investigation. It seems that French does not want to design the post. Under this, so under what circumstances he absconded on the basis of the evidence of 1, 2, and 3. So there is no finding that
Is there a definition of what is absconding under the rules?
yes, madam. Here, my lord, lordship, from the CRPF Act 1949, my lord.
CRPF CRP.
Something is not. That's it.
Is comes under less heinous crime. So now I am saying, section 10 M, my lord. Section 10 may individual absent himself without leave. I am absent with leave. my lord. Absence without leave or without sufficient cause overstays leave granted to him. Overstay is also, my lord.
You mean to say you are absent with leave?
Malab, initially I was in the, initially I
Where is
was.
the leave?
Sorry?
If he was absent with leave, where is the leave?
Malab, initially I was granted leave. And
Then you overstay.
after overwhelming leave, I have not shown. So leave was there. So.
So leave was there for the period you are granted.
period. And overstayed is also, my lord, another example that comes.
Now which section you are reading?
Section 10, my lord. 10 M.
Absence himself.
Yes, absence himself without leave or I come under or we without sufficient cause overstays leave granted to him. As per me, I have put the sufficient cause and I have stated the inquiry officer. And the witness also says due to his problem, he could not join. So therefore, reason was there before the authority. So therefore, my lord, and this is come under the heading of less heinous offense. Section 10. my lord. And here punishment, my lord, shall be punished in imprisonment for a term which may extend to 1 year or with fine. So that they can impose after court martial. That is another aspect. Now, this inquiry has been conducted under Rule 27. CRPO Rule 1950. This is the inquiry under Rule 27. For imposing measure. For the period of absence, which is not willful according to me and the inquiry officer also, because he failed to come to the conclusion that his absence is willful. So therefore, imposing of major penalty dismissal from service is in this fact situation, my lord, excessive and high. That is another aspect of my submission. Inquiry officer has not said. He has not concluded saying that neither my lord statement of allegation is also to that effect. The Honorable Supreme Court in this same case, my lord, where unauthorized absence, but there also charge was not to that effect that willful. The inquiry also officer also failed to conclude that willfully you absent from duty. In that breakdown, my lord, lordship directed there in that lordship directed for reinstatement with 50% accuracy. And my lord, this order thereafter followed by the Honorable High Court, my lord. This Honorable High Court, subsequent case, my lord, I have given. In the case of Pulago with Sudia 2016 1 0, my lord, I have given the counsel judgments, my lord. Next one, 2016 1 GLT 704. Here is also unauthorized absence, my lord.
And the conclusion paragraph 10, 11. And the relief given in paragraph 16. Paragraph 11, this judgment was referred. Here also, neither the search nor the inquiry report officer came to the finding that the unauthorized substance is willful. So on this, relying the judgment of Kushan B. Permanent Mello, the repetition was allowed. Basically, I am here, the procedural lapse, which has been noted by the honorable division bench, interfering with the judgment of the Planet Chingleter, whereby Planet Chingleter said there is no procedural lapse. Procedural lapse in the sense that search is not to that effect, and the report is not also to that effect. How the disciplinary authority has directly come and granted issued the major punishment order. Yes. And my lord, subsequent two judgments, my lord. One is WPC number 2799, my lord, 2017. Here is also, my lord. In this case, I had the occasion, my lord. Here 414 days, my lord, unauthorized substance. Para 7, my lord. Last below pyramid. This
Relied on Parbar.
yes, my lord. 414 days, my lord, unauthorized section, and relying this same proposition, my lord. And this judgment was challenged by the Union of India. My friend was there, my lord. Union of India, he had challenged, and the honorable High Court division bench, my lord, and wherein my lord Justice, my lord was also a member of the division bench. Lordship has upheld the judgment of Single relying the Kushan B. Parmar case that there is no willful allegation in the statement of allegation, and the inquiry officer also there is nothing to that effect, commenting that the unauthorized substance is willful. Therefore, he cannot impose the punishment of removal from service, and therefore the judgment in the repetition passed that termination from service and the granting 50%, both are upheld. So these are my submission on procedural level, not on the document. I say, I may have the unauthorized substance, but unauthorized substance has fallen from the witness of 1, 2, and 3 and my statement. Yeah, I calculating all this statement before the inquiry officer. Although there is no search to that effect willful, inquiry officer also after evaluating evidence failed to come to the conclusion that here is full. So therefore, on this aspect, there procedural left. I pray in view of the decision given by the earlier judgments, these are my submission and application.
My friend is harping on the decision of Parmar willful access, but let us see what is the charge. Let us see what is the charge. I'll just read out. Let us say
Page.
Is 31. Service.
Yes.
Let us say so and so, while functioning as CPGP in C5 CRPF, so and so has committed an act of misconduct in his capacity as a member of the board under section 11(1) CRPF in that he deserted from the company lines on 14/10/2010 at about 1700 hours and still absconding without any information or any prior permission of the competent committee, which is prejudicial to good order and discipline of the force. Here is the case, it is not only the word willful will not come in. He was a person who had deserted the force. Suppose I take, let us argue from his point of view. It was not willful. How does he substantiate that? He only would rely upon the statements made by the three witnesses, whether that is corroborated by anything lordship. That is not corroborated by any documentary evidence to show that these actions was unwillful or willful. In fact, here is a case where he gets himself admitted in a hospital and the hospital says that he has got no psychiatric problems. If he was admitted in 2011, what was he doing till 2016? Till 2016, he has not done anything. 2016, he has got a copy of that advice of the mental hospital. And to add to that, what he has done is, he has suddenly appeared before the disciplinary proceeding committee. Again, he has response. That is his statement.
See, I think the division bench has remanded the matter only on a very short compass, relying on Parmat. There is no dispute that he was absent.
Yes.
There is no dispute that that absence was unauthorized. The only dispute or the only area that is to be
Willful or-
found out is whether it was willful.
Now, if it was not.
So the division bench has come to a finding that there is no finding by the inquiry officer that there was a willful.
Let us go by the division bench order.
uh,
Let us see. What are
No,
the.
because if we go by the division bench order, then the finding of the division bench that the inquiry officer did not go into the aspect of whether it was willful or not willful.
No, it did not. It did not. I will come to that. It did not. First, let us see. How does he substantiate his absence? Lordship will see, there is no explanation at
This is
all.
your argument, but the inquiry officer has to support it by his findings.
Yes, Lordship.
Unless there are findings, or unless the arguments which you are making, the arguments which you are making are not belied by the findings in the inquiry officer's report. That is exactly where the division bench has remanded the matter.
Lordship, yes. The division bench has. remanded
Unless,
the matter.
unless you want to say that even that is not necessary because of some authorities that you want to rely upon.
No, Lordship, the division bench has remanded the matter to look afresh. Because this, otherwise there was no question of remanding the matter.
No, look afresh,
Look at.
but there is an observation of the, there is a finding of the DB
Yes.
that the inquiry officer did not go into this.
Yes.
Unless you can show that the inquiry officer, he was there.
I will show to your lordship. I'll show to you.
All right, we'll continue on Thursday if time permits.
Lordship, I got some difficult, I got some better in Kohima this Thursday, I tell you. Possibly, we can be on Monday or Tuesday.
Tuesday, we have already kept so many matters.
So,
We'll put it on, we'll put it on Tuesday. If time permits, we'll carry on.
yes.
Otherwise,
Lordship,
we'll put it on Tuesday. That's it. You scan through the records and
yes. Then the decision of Parma may be slightly upset by the recent decision of 28th October.
that is for you to urge.
Lordship. Lordship,
But whether it was a case of willful absence or not, unauthorized on these issues. So
Substantially, add the major number.
yes. Sometimes it is not necessary to express. Sometimes it is not necessary to express. It has to be part. List on 8th.